To mention daily list item number 18, my lord.
Yes,
My lord, I have the telephonic instruction from the client to withdraw the petition, my lord. They have amicably settled the issue outside the court, my lord. With a liberty, my lord, may be please to allow to withdraw, my lord.
okay. Both sides are duly represented. Upon instructions, Mr. A.R. Royan and counsel for the petitioner submits that the matter has been amicably settled outside the court. And therefore, he has instructions to withdraw the same. With liberty to approach again if side raised. Prayer is allowed, matter stands dismissed on withdrawal with liberty as paid.
Obliged. Can I have a motion tomorrow, my lord?
Due to the purpose.
I am obliged. I am obliged.
Please, my lord. My lord, the election petition 1 of 21 is listed on 15th. My lord, yesterday we had filed an IA in that case. May I pray, my lord, the same may be directed to be tagged on water record on 15th.
I think it will come with, you'll have to, it will come by listing, by way of listing.
My lord, perhaps it might not be tagged along with the election petition.
Okay. Yes,
I'm obliged.
yes. Supplementary 19,
Supplementary ordinance item number 19.
Forest.
forest will be required here. SC forest,
You are just outside.
Daily list.
after Sunday.
Close.
At me, but I have a urgent matter. It is tender matter. If it is not taken up tomorrow, my petition is be in first class.
Okay,
So
tomorrow.
I have given the number. And moreover, one more thing I tell, it is civil bench 1, civil bench 4. I think for this petitioner, your lordship once conducted a case. It was told by my client. So I have no problem.
No, let it be before any other bench.
I have no problem, my lord. But suppose tomorrow your lordship says, no, I will not take this matter, then to my lord,
Okay. Okay,
I don't hunt for bench. But
it's okay. I'm not accusing you of that.
Lordship, it may come tomorrow, my lord, as motion of like.
Daily list item number 1 for admission.
This is a ferry settlement matter. The lordship will kindly see, I am on the land valuation certificate provided by the ultimately deputy commissioner. Page 37 may kindly be seen.
82,900.
My lord, yes. That is in violation of the, my lord, that is without any basis. They do not have any instruction to do that. Your lordship will kindly see that page 38. This is the zonal valuation. As per the zonal valuation, the valuation comes to 19,44,000.
It's 38.
38, my lord. This is the prescribed mode of giving land valuation certificate. And as your lordship seen, my lord,
Yes.
in respect of the petitioner's village is also at page 38, serial 11,
Yes.
Dokuchu. So rate is prescribed, my lord. As per this rate, the amount comes to 19,44,000 as per the zonal valuation.
Yes.
But they have given a market valuation of 82,90,000, which is, my lord, it is nowhere prescribed. My lord, your lordship will kindly see the land valuation certificate given in respect of the petitioner, my lord. Page 46 and 47. That is based on the zonal valuation certificate. This is the certificate, my lord, 11,28,000 and 46 and 47 is 14,10,000. So my tender value was, my lord, 22,55,555. So this land valuation certificate provided by me covers, my lord. It follows the rules. So now your lordship has issued an order on, my lord, 9/12/22. Lordship will kindly see 9, honey. 9/12/22. The lordship directed, last page, last paragraph, considering that the main grievance of the petitioner is regard to the indication of the market value of the land in the land valuation certificate as well as manner in which settlement order was reviewed, the court is inclined to direct the deputy commissioner to specifically instruct the learned government advocate as to the legality of the mention of the market value of the land in the land valuation certificate of the writ petitioner. Moreover, the respondent number 2 director shall also provide relevant records to the learned departmental council.
Where is the
For the-
tender, where is the tender conditions? with regard to
Tender
the land
condition
valuation?
is that, my lord, your lordship will find that in affidavit filed by respondent number 7 at page 65. Clause number 7, man. Has your lordship got it?
Yes.
Yeah, the tenderer have to submit certificate in support of periodic patta lands in his own name within the district or subdivisions of the value not less than the bid tender amount from the deputy commissioner, additional deputy commissioner, southern subdivision officer of the or the subdivision officer. So the valuation has to be supported by the land valuation certificate. His valuation was, my lord, 23,09,999. And as per the zonal valuation, his valuation comes to 19,44,000. So therefore, the valuation certificate market value provided by the petitioner, it doesn't match the zonal, my lord, the government prescribed valuation as per page 38. So what,
But usually we see, in fact, there are a lot of litigations which we deal with regard to land compensation cases.
Yes.
So in land compensation cases,
that is different, my lord.
it's
Land
market
compensation,
value.
market value. Market value means on the basis of, there is a prescribed mode of doing the market value. But here the prescribed rate is, my lord, prescribed mode is, my lord, zonal valuation. My lord,
No,
I am
but
just
if
giving one judgment.
If the
Your
circle
lordship may
officer
see it.
says, if the circle officer says market value, Gaungura says market value.
No, that,
How can we
your
say
lordship has
correct?
only seen this. When the complaint was filed, ultimately the deputy commissioner, my lord, set aside that judgment. Ultimately, deputy commissioner, my lord, set aside that, then there was paragraph 2, my lord, paragraph 2. May I just read this? My lord? It is similarly relating to the same paper. The present petitioner is the accused number 2 in the aforesaid complaint case, and the accused number 1 was the circle officer, Sabua Revenue Circle in the district of Dibrugarh during the year 2013. The accused number 2, for the purpose of submitting his tender for settlement of so and so ferry service, applied for land valuation certificate. On so and so, accused number 1 circle officer, against whom cognizance has not been taken by the learned trial court, prepared a valuation certificate regarding the valuation of land belonging to the present accused petitioner on the basis of the report of the concerned lot mandal. The additional deputy commissioner on so and so issued a valuation certificate in his favor with absurd valuation of his land on the basis of the certificate of the circle officer aforesaid, without following the government notification regarding fixation of land valuation of the area zone, the zonal valuation. The present accused petitioner used the said valuation certificate while submitting his tender. It is alleged that the accused petitioner used the valuation certificate aforesaid, knowing the same to be false and not based on official records, and dishonestly used the same as genuine and submitted it with his tender documents and got the settlement of the aforesaid service contract. Thereafter, on being approached, the deputy commissioner Dibrugarh, after inquiry, found the said valuation certificate to be not as per the government notification. So in one case, my lord, deputy commissioner has cancelled. Then subsequently, my lord, he came for quashing of the matter under 482. That was not allowed by this court. But here, my lord, as soon as the report is received, my lord, deputy commissioner cancelled the certificate provided by the additional deputy commissioner based on the circle officer's report. So therefore, my lord, the land valuation certificate which has been provided by the authorities, my lord, this is without any basis. There is no basis to it. And the government, my lord, that zonal valuation, my lord, provided by the government that has been violated. So, and now the settlement has been settlement to the, in favor of the respondent number 7, my lord. He could not pay the amount. So therefore it has been, there is an order of cancellation.
Whatever is there.
Since the lessee failed to pay this money on due date, may be initiated. Manager will initiate in this regard, your honor is requested to give necessary suggestion for further operation. He failed to give the kiss money, so therefore the ferry is being run by the department. So my submission is that, my lord, the land valuation certificate provided by the authorities is without any basis. This is the latest, my lord. Now the ferry is being run by the department because he has failed to pay the kiss money. But again, if he pays the kiss money, it will come back to him. And the deputy commissioners, my lord, affidavit given by the deputy commissioner, your lordship will kindly see, your lordship's order has been seen, my lord, and affidavit filed by the respondent number 3, your lordship will kindly see that he doesn't say anything, my lord. It's very surprising.
No, he says, he has said, she says,
The basis of the land valuation not given, my lord. This is what he
no,
says.
it's Gaura certificate.
Yes.
No, no,
She said
Gaugra
it was
certificate, my
produced
lord, Gaugra certificate is not the recognized board of giving land valuation, sir. Only thing is the zonal. He says valuation certificate is in the, as per the circle officer. Who is the circle officer? Who has allowed him to give the genuine valuation certificate? In other case which I have given in the judgment, the deputy commissioner cancelled it because it is not as per the zonal valuation. The lordship will see that judgment wherein the deputy commissioner Dibrugarh, my lord, in a similar circumstances, my lord, cancelled. So if the land valuation certificate is not based on any, my lord, guidelines provided by the government, it has to go.
Yes, Mr. Sharma.
And
Well, the
presently,
record
my
is
lord, it
here.
is being
Just
run by the ferry department. So therefore, the petitioner being the second highest bidder, his bid is liable to be considered by the authorities unless they go for retendering because of failure on the part of the respondent number 7. So your lordship, if your lordship goes to the affidavit of the respondent number 7, that is in not in violation, that is in violation of your lordship's order 9/12/12. Because your lordship said, what is the basis of the valuation? He doesn't say anything. He says it is based on circle officer. May I just read that affidavit? Paragraph 3.
I have noted that.
Yes. He says, my lord, valuation was issued from so and so data so on the basis of the report submitted by the circle officer. As per report of the circle officer, so and so the zonal value along with the market value of land measuring so and so of the village had been assessed as per the latest zonal valuation statement and report submitted by the local Gao Pradhan. Gao Pradhan doesn't have any, my lord, right. Nobody has given him any guidelines to the Gao Pradhan to give any certificate. My submission, my lord, the lordship. So on the basis of it, my lord, since the government could not show any instruction or any notification as regard land valuation certificate on the basis of the market value. So therefore, and there being a zonal valuation notification, so that the certificate provided by the deputy commissioner is liable to be satisfied. And the present ferry, my lord, petitioner being the second one and the first one having failed to pay the his money, my lord, his petition is, his tender is liable to be considered by you. Deeply obliged.
Yes,
May I please, Milord, I am appearing for the respondent number, private respondent number 7.
yes.
By this petition, he has as well, Milord, two things, Milord. One is valuation certificate and another one is the settlement order. Milord, my humble submission, in exercise of judicial review power, how far this court examine the valuation certificate issued by the respondent, official respondent. The procedure followed by the deputy commissioner in the certificate itself disclosed that the certificate was issued on the basis of report submitted by the circle officer based on Mondal report and the village headman. Normally, any dispute arises, if I made a complaint before the deputy commissioner, my lord, definitely deputy commissioner will forward the application to the circle officer. Circle officer in turn forwarded to the Mondal. This is the procedure, my lord. This is the procedure followed, my lord, by the department and the state authorities, my lord. Now, what I submitted before your lordship, that my first submission will be here, the power of judicial review, my lord. If your lordship allow me, because perhaps your lordship already aware of it, I am relying on judgment of Honorable Supreme Court reported in 2018, 18 SCC, page 83, my lord. I am supplying a copy. Page 83. Paragraph 30, my lord. It deals with the judicial review. Paragraph 30. May I read it, my lord?
330.
30, my lord.
Yes.
We are also one with Mr. Venugopal about the scope of judicial review in such matter. The court in exercise of judicial review is not concerned with the correctness of the finding of fact on the basis of which the orders are made, so long as those findings are reasonable and supported by evidence. The court does not substitute its judgment for that the legislature or executive or their agent as to matter within the province of either. The court does not supplement the fact of the expert by its own review. Undoubtedly, this court is not sitting in an appellate authority over the decision taken in making such an appointment or is not supposed to substitute its view for that of the respondent authority. However, this court of judicial review certainly extends to examining the decision-making process and to see as to whether appropriate process legally permissible has been undertaken when taking the decision.
I am aware, you see,
Milord,
no, not that. You see, I'm just reminded of the land valuation of one very high value businessman now settled in UK, where the guarantee was given of for an agricultural land to the extent of rupees, I think 5,000 crore. You remember that? No. He was the owner of airlines, liquor baron, Haryana land,
Yes.
inaccessible land. And when the land was attached by the bank,
Yeah.
the person came and said that I don't even know that this land was mortgaged to someone. For you have read that, I believe. Land valued at not more than 5 lakh. Was mortgaged for 5,000 just because somebody gave a land valuation.
Even Milord, Milord, what I find, Milord, in exercise of judicial right, even the imputes on the basis of which certificate issued, this court in exercise of judicial review power, Milord, cannot examine those imputes even. That
No,
is,
Mr. Pathak, you have to satisfy me more than that. The reason is, number one, in 226, when we are examining the validity of citizenship, persons with doubtful citizens, whose cases we are examining, we are going into the land valuations, the authenticity of the Congress certificates, authenticity of the school certificates.
Uh-huh.
Those things are being examined to
Every-
find out whether the person
Bro,
was rightly entitled to that or not.
no, those documents, my lord, those are evidence. Now in this present case, my lord, in exercise of judicial power, my humble submission, whether the procedure prescribed by under the law or procedure prescribed, the normal procedure prescribed, followed or not, that is the question, moot question here. My humble submission before your lordship, that there is a, yes, zonal valuation. So in your lordship rightly pointed out, in the land acquisition case earlier, valuation, there is no such thing of valuation of land, only compensation of land. Even then court
No
asks,
market value. It's always. based
no,
on-
now it's after 2013, Lord, I have gone to it, both the act, earlier act also there. Now the present act in section 26 said market value and procedure prescribed. The first condition is the valuation fixed by the government for registration purpose. Second, sale deed. Third, any settlement arrive at between the parties, between two parties, one party is government. That settlement, whichever is higher. If the land value fixed by the government is higher, then that will be the value. If the sale deed value is higher, then that will be the value. And even then thereafter, that will be multiplied by 1, then another again multiplied by 2. That is the language of section 26 of the Act 13 million. Therefore, not only the zonal value, even the rules million in the present rules, what they want the value of the land.
Where is the rules?
68, my lord.
Some fishery. Fishery.
No. The management of it. It's 16I, my lord. Has your lordship got it?
Just now. Rule? Which rule?
68, my book, 68, my lord.
No, G-
Studies rule.
GH.
Certificate in support of, my lord, what is?
Yes.
Certificate in support of periodic battalion of value not less than the bid or tender money in his own name within the district of from the deputy commissioner, the additional officer, Sodor subdivisional officer of the district or subdivisional officer of the subdivision concerned should be employed. Here nowhere said that it is zonal value, it's a value. Your lordship.
Yes.
Therefore, my lord, and if your lordship look at the certificate mentioned both the value, my lord, not only the market value.
Where is that?
Yeah, just your lordship kindly have a look on the certificate.
Yes.
$37. Hmm? It is 37, my lord, page.
Yes, I'm there.
2 bigger 2 quarter line of village Daokishi under Mojan Nol has been assessed 19 lakh 44,000. Only rupees 8 lakhs per only per biga as per zonal valuation for the year 2020 and the market value. The both the components are there, my lord. In the certificate, zonal value also recorded as well as market value. Now the question cropped up, my lord. The authority, the IWTC accepted the certificate and take the zonal value, market value. Whether that is bad or good. And that too also Silpi construction case clear. Am I clear to your lordship, my lord? In certificate, there is nothing wrong, my lord. Certificate mention zonal value as well as market value.
You are clear, but at times the head is thick. Yes,
So therefore, my lord, what I am on, my lord, when a certificate disclose the both the value, my lord, zonal value as well as market value, what is wrong with the certificate? And your lordship, he said that zonal market value, there is no concept. But the market value is concept is there. And in one judgment of the Honorable Supreme Court, my lord, with great respect, my lord, 3 judgment judgment. In that judgment, my lord, Honorable Apex Court held that the certificate or any decision taken on some inputs, my lord, the court cannot, in exercise of power under judicial report, cannot examine those inputs, my lord. 3 judgment, my lord. Yes, I am supplying it right now. my lord. 2017, 2017, 16 SCC 568, my lord. Where are we?
17, 16, 568.
Yes, my lord. 568. This is a 3 judgment, my lord.
Yes,
One line, my lord, paragraph 22. 1, 2, 3, 4, 5, 6 line from the bottom, my lord. Paragraph 22, 6 line. Has your lordship got it?
yes,
6 line from the bottom. Since the decision, your lordship, has you got
yes.
it? Since the decision of the competent authority of the central government is based on such input, it is not open for us to sit over that decision as a court of appeal. There is some input. What here in this case, present case, what are those inputs? Cargolopija report, Mondal report, as well as village headman report.
Who's appearing for revenue?
Yeah, Deputy Commissioner, senior is appearing.
No, revenue department is not in this case. Okay.
Now coming to Milord, what I submit before your lordship, in view of law laid down law, Milord.
Yes.
The authority issued a certificate disclosing both the values, the zonal value as well as market value. By following the procedure, obtaining report from the circle officer, Mondal as well as village headman. Well, look, there is nothing infirmity or illegality in the procedure adopted before issuing the certificate, and therefore there is nothing to examine in this certificate, and there is no illegality. Now, I am coming to the next point. This is the writ petition. What is the pleading in the writ petition? Very essential, my lord. Otherwise, your lordship will not take it up because it is law. This is the law of the land. What is the pleading in the writ petition? His allegation 3, my lord. One is the certificate, market value certificate was issued without any basis. 2, it's not static. 3, then zonal valuation is there, therefore no market value. Apart from that, the procedure followed, no allegation. Not a single whisper that the procedure was not followed in issuing the certificate. There is nothing. Whether, now question comes, whether this court will entertain that plea. In my humble submission, your lordship will not take up this plea. In view of law laid down by the Apex Court in judgment reported in 1988 4 STC 534. Paragraph 13, my lord. Paragraph 13. An relevant portion at 543, my lord. (543). Has your lordship got it? 6th line, my lord. In our opinion, has your lordship got it? In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is a writ petitioner, must plead and prove suspect by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded or evidence in support of such fact is not annexed to the writ petition or to the counter, as the case may be, the court will not entertain the point. Now, in our present case, my lord, I submitted before your lordship, his point is 3. No, without any basis, not static and zonal valuation there, therefore that. So for procedure part, he has not agreed. Therefore, my humble submission before your lordship cannot go into enter into that venture whether the certificate was issued validly or not, procedure followed or not, those are not the allegations made in the writ petition, not a single which part, and therefore your lordship cannot take it up. Will not take it up. And now the third question is here. The authority accepted the valuation certificate. Zonal valuation was not there as well as market value. Court authority accepted the market value certificate. Whether this court can examine that aspect. That also your lordship will find Shilpi construction judgment, my lord. Hello, sorry, my lord. In this case, I have one copy only. This is judgment reported in 2020 16 STG, page 489, my lord. Paragraph, my lord. Your lordship will find page para 20. Yes,
Please read.
I'm giving it, my lord. My lord, I mark it, my lord, the authority who has float the contract or tender and has authored the tender document is the best judge as to how the document have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. Here the authority who floated the tender, who authored the tender, accepted the tender valuation certificate. Even if in case of two view possible below, the view accepted by the authorities must be accepted. Now, coming to the judgment relied by my friend, my lord. That judgment, my lord, my humble submission, if he relied, let him go to the deputy commissioner and approach the deputy commissioner. That would be the best way. In the judgment, one certificate was issued and that certificate was cancelled on objection. After cancellation, a criminal case was instituted. And the in the judgment only said that the valuation certificate was issued in an inflated rate, not on general rate. That does not mean that there will not be a market value, and that there was nothing on the record to show that the certificate was issued market value on the basis of market value. There's not record, and this facts, the facts narrated in the that case and the present case is vast different, and therefore, I need not required to place judgment without doing the simple difference in the facts.
It's a world of difference.
Whole of different, my lord. That case is a criminal case, my lord. Once the certificate was issued, then cancelled by the authority themselves, finding that there is a inflated rate was quoted, and thereafter the prosecution launched by an interested party, not by the government, but by a private party. And therefore, the judgment is no way connected with this present case.
In that case, there is a reference to 1966, I think, Supreme Court.
Where?
That decision of world of difference.
Yeah, with the constitutional
I think
judgment.
66.
Yes, yes,
Judgment is
yes, yes,
referred
yes.
But I forgot the citation.
No,
You said world of difference I remembered, but I forgot. the title.
no, that constitutional, that day also, in one case that was referred by the court. Therefore, my lord, what I sub,
Just give that, there's world of difference. What is the citation?
my lord, right now I'll get supplied it to the itself.
No, only the citation. I don't need the copy.
My lord, my lord. And therefore, what I submitted before your lordship, my lord, that there is nothing wrong in issuing a certificate by the authority and also accepting the certificate by the authority concerned. And therefore, my humble submission before your lordship that this writ petition without merit and liable to be dismissed. That's my humble submission.
Yes.
My lord, the rules does not say whether the department has to accept the market value or the zonal value, my lord. Lordship may already gone through the rule 16H, my lord, of the ferries rule, my lord. May I read again, my lord?
That is rule 16,
16H, my lord.
16(8)
H,
H.
my lord.
Yes.
My lord, certificate in support of periodic patta land of value not less than the bid tender money in his own name within the district or the subdivision from the deputy commissioner, additional deputy commissioner, Sadar subdivisional officer of the district or subdivisional officer of the subdivision concerned should be enclosed. That on the basis of
That
the
I got, Mr. Kotaki. That is Kotak Mahindra Bank. Yes.
yes. The lordship in our affidavit also we have filed one affidavit, my lord. The paragraph 3 is relevant, my lord. Affidavit filed by the respondent. My lord, paragraph 3 of our affidavit, my lord, filed by the respondent number to the director, running page 70, my lord.
17.
My lord, 70.
Yes.
Paragraph 3, my lord. May I read, madam? That in regards to the statement made in paragraph number 5 and 6 repetition, the deponent begs to state that as there is no specific guideline in the control and management of ferries rule 1968 regarding the land valuation which was to be considered, the tender committee had accepted the land valuation of Sri Utpal Kumar Das, who is the private respondent, my lord, issued by concerned additional deputy commissioner, rule 16 of the control and management report is herein under. Already the rest is aware, my lord. And my lord, the case which was my learner senior is relying, my lord. It's a totally different case, my lord. The lordship may kindly have a look, paragraph 11 of the judgment. Fourth line from below, my lord. My lord, got it?
Yes.
In the instant case, the complainant has laid the foundation of the complaint to the effect that the present accused petitioner furnished the valuation certificate as one of the tender documents to get the ferry service settled in his favor, knowing that the said valuation certificate was cancelled subsequently. It's a forgery of document, my lord. It is not a similar case that the deputy commissioner has rejected because it was on the basis of the market value or it's a basis of the zonal value. The facts of the case is totally different, my lord. This is my humble submission, my lord. And lordship, I am relying through judgment, my lord. Lordship, I have given a list of books, my lord. Lordship is well aware, but I'm just only giving the paragraph numbers. In the Michigan Rubber India case, my lord, reported in 2012, 8 SCC 216. I am relying paragraph 23, my lord. My lord is well aware, so I am not reading all those, my lord. And the lordship may, I am relying the another judgment, my lord, the Tata Cellular case, 1994, 6 SCC 651, paragraph 94, my lord.
Just now, man.
My lord.
Just now. Yes.
Lordship, in 2012, 8 SCC 216, I am relying paragraph 23, my lord. Lordship is
Yes.
well, so I am not reading all those, my lord. And from the Tata Cellular case, Lordship, I am relying paragraph 94, my lord.
Yes.
And then Lordship, the 2019 14 SCC 81, I'm relying paragraph 37, 38, the Airtel Infotech Limited case, my lord. Para 37 and 38, my lord. And Lordship, the present status of the matter, my lord, I have just received the instruction from the director. I have mailed Lordship. Dada. The Lordship, may I read the relevant paragraph that I have received just now?
Yes.
The lessee had not executed lease agreement for second year, that is for the financial year period 1/4/2023 to 31/3/2024, and also not deposited first kiss money of second year 2023 to 2024 till date. The director IWT had requested the executive engineer IWT division Guwahati to take over the ferry service from the lessee and run it departmentally until the this money is paid by the lessee, while data number so and so dated 30/5/2023. And exactly accordingly, the executive engineer IWT division has Guwahati has operated the ferry service departmentally. That is running by department. This is the present status, my lord.
But why it is not cancelled and why?
Because there is a
Officers-
rules, my lord. There is a ferries rule, my lord, 27(3). Lordship, may kindly have a look.
20?
27(3), Lordship.
Yes.
Lordship, I don't have copy. I have
No,
given
it's
the
okay.
map.
Okay.
Lordship,
I got that. I see that.
ma. If he will deposit the kiss money, then he can run the ferries. But during that period, this he will not get any revenue.
There is 27(3).
27(3). my lord.
Yes.
This is my submission, Lordship. I'll take and give it to Lordship 27(3). And my humble submission is that we have to go by rules, my lord. Department have to follow the rules. That rules, there's nothing specified whether we have to take in the market value or the journal value, my lord. But the department has rightly settled the ferry with the very highest bidder, my lord. This is my humble submission, my lord. I'm deeply aware.
My lord, your lordship will kindly see, I will respond reply. My lord, the page 46. Nobody can be allowed to act arbitrarily and without any basis. The page 46, the certificate given in respect of the petitioner, that is on the basis of the zonal valuation. I have shown, my lord, earlier, page 46 and 47. These are based on zonal valuation. And the deputy commissioner, your lordship's order dated, my lord, at page 9/12/22. I'll just like to point out again, 9/12/22. specifically the last paragraph. Your lordship indicated that the deputy commissioner showed. You see, grievance of the petitioner in regard to the indication of the market value of the land in the land valuation certificate as well as manner in which settlement order is reviewed. The court is inclined to direct the deputy commissioner to specifically instruct the learned government advocate as to the legality of the mention of the market value of the land. This has not been addressed. Now the zonal. So therefore, if they say, Malad, it has come from the circle officer, Gauguraj and all, they must be having something which will allow them to provide the market value. It cannot be whimsical. Your lordship will tell you how the zonal valuation is done. The notification copy I have given. This one. Your lordship will kindly see the notification. Zonal valuation, Malad. Has your lordship seen this one?
Yes, yes, this is the only one available in the internet. When you were arguing, then only I found out
Yes.
it is.
So the zonal valuation, Malad, is based on the government guidelines, and the publics are allowed to, Malad, put their objections, and then thereafter, Malad, it is
This is-
published.
This I have already
This is-
opened here.
This is what it is. So therefore, my lord, the market value, there is no instruction as such, because in all the other judgment I have pointed out, they are, my lord, deputy commissioner subsequently cancelled. Market valuation is given to the person, my lord, only in, my lord, in collusion manner for the purpose of acting for helping somebody. There is no basis for giving any market value. So therefore, my submission is, my lord, as per your lordship's direction, deputy commissioner avoided giving the order. And second, my lord, the market valuation, there is no guidelines from the government for providing any, my lord, how to provide market value. For zonal valuation, there is a proper notification. As per the government, they give the zonal valuation, and accordingly it is published. So it is published at page 38 of this request. So therefore, the market valuation having been provided by on the basis of the circle officer, and the same being without any basis or without any notification from the government, that itself is wrong. So therefore, that market valuation is liable to be satisfied. And the deputy commissioner, my lord, did not act as per the order passed by your lordship.
I will just, in the course of the day, I'll ask the revenue
Yes,
council, because you see,
yes.
this is something I forgot long back.
So this is going to impact in many other, my lord.
No, I'll tell you, I'll tell you something. You see this, this notification which you have given,
Yes,
this one,
yes, zonal valuation.
zone valuation,
Yeah.
there's something in it, I should point it out to you. You see, in the first line, you will find reference to
Government letter.
REGN,
Yes, ma'am.
correct? So what has happened is that under the, for the purposes of valuing a sale deed, the revenue authorities have come out with a circular which says that the stamp valuation, for the purpose of stamp valuation, it will be based on, and the registration fee shall be based on zonal valuation. It is based on that circular that these are being issued. So in the master circular, where the government of Assam and what you call notified this zonal valuation is only for the purpose of registration. It is for no other purpose.
Maybe, my lord, but if the circle officer gives an evaluation, this has to be on the basis of some government notification. He cannot be king and queen to give a certificate that the land valuation is according to me this, and this will be accepted by the government. It has to be on the basis of this is a rule of law, my lord. He has to act on the basis of the some government instruction or notification. On what basis the valuation certificate is? In the judgment which I have shown, my lord, I just wanted to show that the deputy commissioner, on the basis of the complaint, he my lord, cancelled the zonal valuations, land valuation certificate based on the circle office. So
Because
here also, my lord, if your lordship,
under the old act, Mr. Photography said that about the new 2013 act,
yes,
there is a reference to what you call market value. But in the Land Acquisition Act, the words used are true value.
Yes. My lord, in short, my lord, if the government accepts land valuation certificate from the circle officer, it has to be based on some notification or some criteria.
Sometimes.
If your lordship finds that the criteria is there, because this is going to impact many other, my lord, for the first time, your lordship will be deciding whether when in this kind of matter, whether it has to be based on the circle officer, because the zone market value will, my lord, if there is a proper guidelines from the government, yes, maybe market value can be accepted. But the guidelines is to be provided by the government. In one case, your lordship has seen that the deputy commissioner has cancelled it. Circle officer also must act on the basis of the government notification. He cannot act arbitrarily. So therefore, my humble submission, my lord, it is on the face of it without any basis. So therefore, my lord, it is liable to be set aside. And my lord, now they having failed to provide his money, my lord, the petitioner, they are liable to, liable to, your lordship may direct them to consider his tender, or they may go for retendering. Obliged, your lordship.
But past what is in course of the after I speak to.
Yes, revenue authority. It is important matter, my lord. Revenue authorities must come up, my lord, with a suggestion on how it is done, land valuations by the circle officer. And what is the point of the zonal valuation?
No, that I remember because I
Yes, yes.
long back when we used to run the deputy commissioner's office to
No, I understand.
execute sale date.
No, land
But your
valuation is
lordship
different.
query clarified by the section 26 itself, that land valuation declared under the Stamp Act only for the registration purpose. That also 26 clarified
26
of 2013 Act. I did.
But there also notification is there.
No.
No,
No.
the collector shall adopt the following criteria.
Mother, in all this Sujan Bazar, all these areas, for the purpose of stamp mallet, land valuation is given by the government.
No, that is DLR zonal valuation.
Yes, no, the land valuation, land valuation in respect of Saurabh Kakati's room, house, it is there. If he wants to sell his house, well, not. then
That
the-
is
that
for
land
registration
valuation- It is applicable.
He is not giving his own. Okay. Bas ho gaya.
Malad has given them as a CAB Malad.
No. I'll dictate orders today.
May I please your lordship?
Yes.
The petitioner here in your lordship has filed this petition in lordship, apprehending evictions from their land under your lordship, Tolmora Forest Village, your lordship. Now, your lordship, I have in the writ petition, your lordship, annexed A series, your lordship. I have annexed certain documents, your lordship, which from annexer A, your lordship, page 26 to page 40. Up to page 67, your lordship. And in fact, in additional affidavit, your lordship, I have in a tabular form, your lordship, I have stated, your lordship, documents, which document belongs to whom, your lordship.
Your lordship, if your lordship takes up my additional affidavit, your lordship. Oh, sorry.
Additional affidavit.
Lordship,
When did you file it?
additional affidavit, your lordship.
When did you file it?
Your lordship, I filed it on 5/6/2020.
It's not here. It's not available. You give a slip in college. It's not available.
Lordship,
College will take it up at 2.
lordship.
Affidavit is not there. You have a copy of your affidavit?
Yes, your extra copy. Extra copy. Not there.
Okay, we'll call it.
Lordship, we take my copy otherwise. Page 82, your lordship.
Yes.
Page 82, your lordship. The 17 petitioners, your lordship. Name of the petitioner, name of the allottee, your lordship, relationship of the petitioner to the allottee, and approximate quantity of land allotted and the date of allotment, your lordship. And this forest village was, your lordship, constituted in the year 1901, your lordship. In fact, those allottees, your lordship, are also, your lordship, their predecessors in interest, your lordship, were forest villagers, your lordship, of that particular village, your lordship. And your lordship, paragraph 3, your lordship, the documents which I have annexed, your lordship, in the writ petition, in details, your lordship, in tabular form I have mentioned, your lordship. Based on this, your lordship, we are saying that we should not be evicted from the land in our occupation. your
No,
lordship.
only for allotment land.
Lordship,
Only for allotted land.
lordship,
But what happens, like you say, there's an allotted land. And there's a huge construction which has been made therein. Is that permissible in a forest area?
no, your lordship, forest village are created, your lordship.
No, village I understand.
Lordship,
The what do you call the the most highlighted village is Swalkuchi.
lordship,
Swalkuchi incidentally is still a village, you know that?
lordship. So I'll be second.
Yes, but there is nothing, no semblance of village in that place. So can that be permitted within within the forest area?
Lordship, once your lordship, a forest village is created, your lordship, so far as this forest villagers concerned, if I am, my predecessors in interest are not the forest villagers, your lordship, then I will have no claim, your lordship. But if my name and predecessors in interest names are there in the Jamabandi of the Jamabandi, your lordship, that is the forest Jamabandi, your lordship, is there, your lordship, then I will have a claim, and that claim, on the basis of that, your lordship, there is a procedure for eviction. It is not that, that is, your lordship, they can resume that land, your lordship, the forest department. And that procedure is there in the, your lordship, in a set of rules, your lordship. Rules for the establishment and control of forest villages, your lordship. Chapter 7, your lordship.
Which rule?
General rules framed under the Assam Forest Regulation.
Which rule?
Your lordship will get it in this book, your lordship. Local action rules, your lordship. Volume 9. Volume 9, your lordship. Page 270.
Two hundred?
270, your lordship. Your lordship, go.
Yes,
270.
yes.
Rules. Rules for the establishment and control of forest villages. Now, one, forest villages may be established within the limits of any reserve forest on sites of the location of which shall be approved by the conservator of forest in writing. Then, your lordship, 2, your lordship, 3, 4, your lordship. The divisional forest officer is authorized to evict summarily from a forest village without payment of cost to anyone who does not comply with or who refuses to carry out his orders so far as they are consistent with the rules or whose conduct impairs the harmonious working of the village. An appeal, however, shall lie to the deputy commissioner of the district, but in the event of the latter disagreeing with the divisional forest, the case must be referred to the conservator's decision and the final. Then 6, your lordship. On the disease of a householder, the name of his male heir will be registered as a forest villager. If he is considered by the divisional forest officer to be suitable in all respects, or in cases where his daughter is the heiress, the name of her husband should be recorded as the householder if he is suitable for employment at forest village. The names of heirs who are minors will be recorded in a forest village when they become fit for work, or in the case of females when married, they marry husbands suitable for forest villages, but nothing in this rule shall be held recognized any heritable right. We don't have any heritable right. Then your lordship may kindly come to 14. The forest department may resume occupation of land allotted to a forest villager by giving 6 months notice to the occupier. Now, these are the, your lordship, procedure, your lordship, so far as the forest villager is concerned. Your lordship. We don't
No,
have any
also-
inheritable.
Also in page 286,
Lordship.
there's a rule for eviction from reserve forests.
Lordship. Now, your lordship, so far as this
So
forest
therefore-
villagers,
therefore, there are two parts, what I understand from this 72C.
lordship,
One is an allotted land, and the second is land which is not allotted. From
lordship,
there, they can evict them.
everything. Now, this procedure, so far as will have to be followed, in my humble submission, if they want to evict us, your lordship, they will have to resume it, your lordship, by exercising power under Rule 14, your lordship. Now, my case is this, your lordship, that since we are allotted land, your lordship, as a forest village, your lordship, which our predecessors in interest are there, your lordship, for long, your lordship. then this should have been followed. Now, your lordship will kindly take up one judgment, your lordship. This is division bench of this honorable court, your lordship. Nineteen 87 SSC online, Guwahati 15. In fact, this says, your lordship, 1987 SSC online. Your lordship will kindly come to para 5, your lordship, statutory provisions. Before the submissions advanced by Sri Das or Sri Das are dealt with, we may have a cursory look at the relevant provisions finding place in the rules made under Assam Forest Regulation 1891. Chapter 7 of the rules that your lordship has already gone through is relevant for our purpose, which has dealt with rules for the establishment control of forest villages. Rule 1 states that forest villages may be established within the limits of any reserve forest on sites, the location of which shall be approved by the conservator of forest in writing. The purpose behind establishing villages too has been spelled out in Rule 2, which reads, then your lordship. Rule 5 has dealt with the limit of land which can be allotted. We are not concerned with this rule at present case. The only other relevant rule is Rule 14, which has stated that Forest Department may resume occupation of land allotted to a forest village by giving 6 months notice to the occupier. Then your lordship, there is a discussion, your lordship. Ultimately, your lordship, detailed discussion on principle of natural justice, your lordship. Then para 13 was the relevant, your lordship. Para 31. All told, it may be stated that though in the present state of Indian law, it cannot be held that giving reasons is a part of natural justice, but non-arbitrariness of an action being increasingly recognized as a part of the equity clause enshrined in the Constitution as giving of reasons take care of non-arbitrariness. It can definitely be held that even if giving reasons may not be a part of natural justice, the same does not take care of likelihood of violation of Article 14. That apart, the requirement of giving reasons should vary from case to case where an order is likely to prejudicially affect a person's. Reasons have to be recorded to give meaning and content to his remedy of appeal, review, or approach to writ court. I would therefore say that in the resumption notices, which may be issued under Rule 14, it would be do well to give reason for resumption, which would enable the aggrieved party to show its cause in a better way. It would also assist the court of law in case challenge is made to the resumption to know if the need for it based on relevant and German considerations or is grounded on irrelevant and extraneous consideration. As the learned Advocate General has fairly stated that on challenges being made to the issuance of resumption notice, the authorities shall have to satisfy that the exercise of power was not malified or colorable, giving valid and good reasons should raise the presumption of acting in accordance with law, with the result that the burden would be thrown upon the affected party challenging issuance of notice, so that what has been recited is either not correct or is not relevant. Recording of reasons should also take care of substituting the same with other reasons in case of challenge. As in the present case, the order of cancellation cannot be taken to be a resumption notice, as no power has been shown to us by the respondent to issue the cancellation order. It is held to be ultra vires. The petition accordingly allowed. Now, your lordship, ultimately, your lordship, they can exercise power under Rule 14, and your lordship, by exercising that power, they can, your lordship, issue notice to one showing reason, your lordship, and thereafter, your lordship, if they are not satisfied with our replies, they can evict us, resume the land. That is the procedure as has been upheld by this honorable court, your lordship. In fact, in para 10, your lordship, the learned Advocate General as relevant client, your lordship, has admitted, your lordship, that since cancellation notices are there, but there is no reasons recorded, para 10, your lordship, therefore this is bad, your lordship. That is the concession made by the then, your lordship, Advocate General, your lordship. Insofar as the question of unnecessary is concerned, it has been rightly considered by the learned Advocate General that allotment made earlier in favor of the petitioner would not have been cancelled without affording reasonable opportunity to them to so cause in this regard. It is however urged that provision of Rule 14 of the rule that 6-month notice should be given meets the requirement of national justice, which really lies embedded in this rule. It has, however, been contended by the learned advocate general that the reasons of resumption are not recorded in the notice, but where a challenge is made to the resumption, the authorities shall have to satisfy the court that power was neither used mala fide nor was it colored. Now, your lordship, here, your lordship, there is no question of even your lordship such notices being issued, your lordship. Now, your lordship, in fact, your lordship, while the other day, your lordship, this matter was heard, the heard, your lordship, they have relied on a judgment, your lordship. That judgment probably your lordship has already gone through, your lordship. But your lordship, my humble submission will be, your lordship, those judgment, that judgment, your lordship, will not cover my case, your lordship. There are precisely two reasons, your lordship. This judgment has not taken care of the earlier judgment of the division bench of this honorable court, number one. Number two, this rule has also not been referred to by the judgment relied on by counsels for the learned counsels for the, your lordship, forest department, your lordship. In fact, your lordship, if your lordship go to the prayer as reflected from the judgment of itself, your lordship, their case was, your lordship, that in the 1975 there was a letter, your lordship, and that letter, your lordship, on the basis of that letter, they are claiming, your lordship, that their name should be included in the Jamabandi or Jamabandi, your lordship, which is in the office of the forest authorities, your lordship. I have not made such prayer, your lordship. I am not claiming that my name should be included in the Jamabandi, your lordship. This is a specific prayer, your lordship, based on a letter dated issued in the year 1974, that their name should be, your lordship, be there in the copy of the Jamabandi, your lordship. If your lordship comes to the order at
Read paragraph 3.
paragraph 3, your lordship. Paragraph 3, your lordship. A reading of the prayer makes it discernible that writ petitioner seeks for a direction to the respondents in the forest department of the Doctor Assam as well as the Deputy Commissioner Karimganj, Circle Officer Patharkandi Revenue Circle to take necessary steps to enter the names of the petitioner in Jamabandi register in respect of Old Sarmanga, Boro Sabri, Forest Village in terms of letter dated so and so. Then your lordship, if your lordship comes to page para 13, your lordship, the submission, your lordship, by referring to the establishment rules, so and so learned senior counsel submits that the petitioner have been put into possession inside the reserve forest land under the said rules, and that under rules they have a legal right their names being entered in the Jamabandi, and some kind of heritable right also provided in the rule itself. Therefore, most of the petitioners being second generation of the persons who were put into possession inside the forest land as per the order that so and so have a permanent, heritable, and legal right in perpetuity to occupying the forest land. I am not making such a claim, your lordship. That I am making clear, your lordship. And secondly, your lordship, thirdly, your lordship, these issues, your lordship, this rule has not been considered, your lordship. And so far as your lordship, the question of your lordship forest villages are concerned, the judgment, your lordship, says that there is, it has relied on your lordship section 29 of the regulation 29 of the Assam Forest Regulation 18 regulation. 1891, your lordship. Constitution of Village Forest, your lordship. Now these words, your lordship, will kindly note.
Which provision?
Regulation 29, your lordship. Assam Forest Regulation 1891, your lordship.
Yes.
29, Constitution of Village Forest. The state government may, by notification in the official gazette, constitute any land at the disposal of the government a village forest for the benefit of any village community or group of village communities, and may in like manner vary and cancel any such notification. Now, your lordship, the concept of village forest, your lordship, as can be discernible from the language itself, is different from the forest village, your lordship. Now it's a village forest within village. in probability, your lordship. And therefore, your lordship, in rules, your lordship, the word village forest has not been used. Specifically, your lordship, we would use this forest village, your lordship, not village forest, your lordship. And that is within your lordship, or reserved forest that can be constituted by the authorities, your lordship. Now the honorable single judge, your lordship, in the other judgment, your lordship, in my, which all humanity in my command, your lordship, probably has relied on this, your lordship, to give a finding that these people are, and there is no system of your lordship constituting forest villages in the, under the rules, your lordship, under the regulation, your lordship. And so far as your lordship, these forest villages are concerned, your lordship, I also want to make one aspect clear, your lordship. If your lordship takes up the forest, right? Scheduled tribe and other traditional forest dwellers recognition of Forest Right Act 2006, your lordship. Two provisions are there, your lordship. One, your lordship, it's a definition of forest villages, your lordship.
Right to,
Lordship,
what is the name of the act, right?
your lordship, the scheduled tribes and
Scheduled
castes and scheduled tribes.
No, scheduled tribes, scheduled tribes.
Forest Right
scheduled
Act.
tribes.
Well,
Scheduled tribes.
well, I'm just handing over.
Yes.
Lordship. The section 2F, your lordship, forest villages means the settlement which have been established inside the forest by the forest department of any state government for forest operation, or which were converted into forest villages to the forest reservation process, and includes forest settlement villages, so and so, so and so, so and so. Now, if your lordship comes to section 3, your lordship, forest rights of forest dwelling, scheduled tribe and other traditional forest dwellers. These are the, your lordship, rights, your lordship. And H, your lordship. Rights of settlement and conversion of all forest villages. 3H, your lordship.
Yes.
Rights of settlement and conversion of all forest villages, all habitation, unsurveyed villages, other villages in forest, whether recorded, notified or not into revenue villages. So there is a, your lordship, a right has been, your lordship, given, your lordship, under this act to all those forest villages, your lordship, which are, your lordship, to convert these forest villages into revenue villages. Now, if your lordship takes up section 4, your lordship, these forest rights, your lordship, referred in section 3, your lordship, this has been recognized to section 4, your lordship. Recognition of,
No, you see, I have difficulty in following you for a different reason.
lordship,
Number one, that this act, scheduled tribes and other traditional forest dwellers. Scheduled tribe, we understand, but can you be called a traditional forest dweller?
your lordship, there is a,
When your allotment of land is of recent origin, can you be said to be
your lordship, so
a
far as
traditional village?
other, your lordship,
villager.
the traditional forest villagers, your lordship, there, they will have to show, your lordship, that they were living in for 3 generations, your lordship. Then they are called, your lordship, traditional forest villagers, your lordship. Otherwise not, your lordship. They will have to, your lordship. Now, once your
Three
lordship,
generations they have to show.
3 generations, your lordship, or 75 years, your lordship, either of
Which,
these,
which provision?
your lordship. your lordship will. Your lordship, O, 2O.
Two other traditional.
Other traditional forum means any member or community
Three generations.
who
prior
has
to
for at
13
least three
12,
generations
2005.
prior to December primarily resided in and who depended on forest or forest lands for bona fide livelihood needs, your lordship. Now, your lordship, I don't know, your lordship, whether all the petitioners are there or not, but what my claim is, your lordship, and if your lordship, any such exercise is carried out, your lordship, then we have a right to place our claims, your lordship. And if your lordship, after that, my claim is considered and they found, your lordship, that yes, we are not entitled under the, your lordship, this act also, your lordship, then we are out. Even otherwise also, your lordship, if they come up with an affidavit saying that this person's name or their predecessors' interest names are not there in the forest Jamabandi, then also, your lordship, my case, I do not have a case, your lordship. My specific claim is that, your lordship, my predecessors' interests were there, your lordship, since long. And therefore, your lordship, they will either have to controvert it, or your lordship, it will have to be sent back to the authorities, your lordship, to look into that aspect of the matter, your lordship. But your lordship, by relying on that judgment, your lordship, and in fact, your lordship, pursuant to this act, your lordship, there is a, your lordship, central government notification, if your lordship please. There is a process, your lordship, initiated by which, your lordship, these forest villages, your lordship, are thought to be, your lordship, converted into revenue villages, your lordship. This is a central government notification, your lordship, issued on 31/2018, your lordship. A specific issue is, your lordship, conversion of all forest villages, old habitations, unsurveyed villages, etc. into revenue villages under section 318 of Scheduled Tribe and Other Traditional Forest Dwellers Recognition of Forest Act 2006. And they have clarified, your lordship, that this will override every other act, your lordship, the central government, by this notification, your lordship. In the next page, your lordship. Whether the provisions of the Forest Right Act 2006 supersede the provisions of Forest Conservation Act 1980 and the Honorable Supreme Court judgment dated so and so in IS so and so. It is a well settled principle of statutory. This they have said, your lordship, that it will override, your lordship, everything else, your lordship. Now, your lordship, my prayer therefore is that, your lordship may either issue a notice to them, your lordship, asking them to file an affidavit, your lordship, saying whether, your lordship, we are entitled or not, your lordship, under the law or not, your lordship. Or, your lordship, may send back the matter to the authorities, your lordship, to look into our claims, your lordship, and pass appropriate orders, your lordship, on the basis of that, your lordship. This is, your lordship, until then, your lordship, that consideration is made, your lordship, we should not be a lordship affected. Ultimately, it is an exercise to be carried out by them, your lordship. Finding of fact, your lordship, whether our names are there or not in the documents, etc. We are entitled or not, your lordship. If we are not entitled, then they will remove me, your lordship, by giving as per following the procedure of law. And if not, your lordship, then they will go by the law, your lordship. But by relying on that judgment, your lordship, summarily rejecting my claim at the, your lordship, without bringing in any facts into record by filing affidavit, that probably, your lordship, in my humble submission, would not be proper, your lordship. And ultimately, your lordship, for long these people are, your lordship, residing. The problem is this, your lordship, rightly or wrongly, the authorities themselves create such situation, your lordship, allowing people to settle, your lordship. At the very first instance, if they take steps, your lordship, this problem would never arise, your lordship. That's the issue, your lordship. And after all of a sudden, your lordship, after settling everything, they try to unsettle all of a sudden everything, your lordship. That creates problem, your lordship.
Yes.
I leave it to your lordship.
Yes.
The Lordship, the petitioners may have grievances against the judgment rendered in WPC 4775. But unless it is declared to be per inquiry, Your Lordship, it is the law which holds the field. So their legal right, Your Lordship, their locus will have to be examined, Your Lordship, as per the law laid down in this judgment, Your Lordship. So I'd just like to take Your Lordship to the operative portion of the judgment. Perhaps that will make the position of law clear. It starts at, I'll read from paragraph number 21, Your Lordship. Or rather, I'll read from paragraph number 20 of the judgment, Your Lordship.
Yes.
Yes. The meaning of residual land, whether it will also include land under the reserve forest, can be discerned from the provisions of section 29 of the regulations of 1891. A reserve forest is constituted in exercise of the powers under section 4 of the regulations of 1891, which provides that the state government may constitute any land at the disposal of the government or reserve forest in the manner provided therein. The manner to constitute a reserve forest is provided under section 5 of the regulations of 1891, which inter alia provides that whenever it is proposed to constitute any land the reserve forest, the state government may, by publishing a notification in the official gazette, specify as nearly as possible the limits of such land, and in doing so to also appoint an officer called the Forest Settlement Officer to inquire into and determine the existence, nature, and extent of any rights claimed or alleged to exist in favor of any person over any land within such limits. Section 6D of the regulations of 1891 provide for fixing of a period of not less than 3 months from the date of publication of Section 5 proclamation, requiring every person claiming any right to submit a written notice to the Forest Settlement Officer. And Section 8 provides for an inquiry to be made by the Forest Settlement Officer. Section 11(1) provides that in respect of a claim to any right within the limits of the land proclaimed for the purpose of constituting the reserve forest, the Forest Settlement Officer shall pass an order specifying the particulars of such claim by admitting or rejecting the claim wholly or in part. Section 11(2) provides that if any such claim is admitted wholly or in part, the Forest Settlement Officer may come to an agreement with the claimant for surrender of the right or to exclude the land from the limits of.
Yes.
Yes. Section 11(2) provides that if any such claim is admitted wholly or in part, the Forest Settlement Officer may come to an agreement with the claimant for surrender of the right or to exclude the land from the limits of proposed forest or to proceed to acquire the land. Now, paragraph 21, Your Lordship, decides the issue of what happens once the land has been declared as a reserve forest. From the provisions of section 11(2), it is apparent that upon a reserve forest being notified under section 17 of the aforesaid regulations, no claim or right of any person remains over the land under the reserve forest. Section 18 of the regulations of 1891 make it further explicit that even if any right could have been claimed by any person, but not claimed under section 6, such rights would stand extinguished unless before publication of section 17 notification, such person makes a claim under section 6. Now, your lordship has submitted a copy of the gazette notification of this reserve forest, your lordship. So this is a notification of 1901, your lordship, by which the Longai forest was declared as a reserve forest. Now, as per their own statements made in the petition, your lordship, at paragraph number 2, your lordship, of the writ petition, the petitioners have stated that the allotment was only done in the year 1922. The earliest allotment was only in the year 1922. So we can presume that the others came after that. So in this judgment, your lordship, that has also been dealt with, that whether after reservation of the forest, your lordship, can the government exercise powers under the rules, your lordship, to allot land inside the reserve forest to people for their dwelling purposes, which is a non-forest purpose. Para 22. As the procedure referred in section 4 of the regulation of 1891 to constitute any land at the disposal of the government or reserve forest, in terms of the provisions of section 5 to section 18, which is a code by itself, we have to understand that the further notification referred in section 29 to constitute any land at the disposal of the government, a village forest would have to be a notification over any land which would not be covered by the notification under section 17 of the regulations of 1891, meaning thereby that such land which has already been declared to be notified as a reserve forest under section 17 would not be a residual land to be covered by any further notification to constitute a village forest under section 29. Accordingly, any notification under section 29 of the regulations of 1891 to constitute a village forest would not and cannot include any land under a reserve forest which has already been notified under section 17. Consequently, the concept of village forest as provided in section 29 of the regulations of 1891 and the concept of forest village provided in rule 1 of the establishment rules would have to be understood to not be the same concept or interchangeable with each other.
You see, I find more force in the argument of Mr. Bhattakur for the reason that you see this chapter 7
Lordship.
relating to this rules for establishment and control of forest villages.
Lordship.
This the book which Mr.
Yes.
Bhattakur is having, if you can have that book,
Lord.
please give it to him. In this book, please come to page 273.
Okay. Lordship.
This rule starts from 270, correct?
Yes, your lordship.
Now come to 273.
Lordship.
There is a footnote that these rules have been framed by notification under so and so December 1930.
Yes, your lordship.
It is a pre-independent law.
Pre-independent law. So pre-independent laws, your lordship, to the extent they are not in contravention with any existing laws or laws framed by parliament, they continue to be valid. But in this judgment, what the honorable coordinate benches held is that this power to settle people inside the reserve forest.
This was not, these rules were not even referred to.
These rules have been, these are the establishment rules, your lordship, which are referred to in paragraph number 23.
23.
23.
Yes.
Accordingly, any notification under section 29 of the regulations of 1891 to constitute a village forest would not and cannot include any land under the reserve forest, which has already been notified under section 17. Consequently, the concept of village forest is provided in section 29 of the regulations of 1891, and the concept of forest village provided in rule 1 of the establishment rules, these rules, would have to be understood to not be the same concept or interchangeable with each other. In context of such conclusion, we look into the establishment rules. It is noticed that the rules are framed under section 72E, 74 and 75 of the regulations of 1891. Section 72E of the regulations of 1891 provides for the additional powers to make rules by the state government, which again would have to be consistent with the provisions of the regulations itself.
Something is wrong there.
Lordship, paragraph 24, your lordship.
Page 286 shows that it is also for 72C. And this was inserted in 1973,
This was in which provision, your lordship?
page 286, 72(3). These rules for eviction was inserted in 1973,
I'll just.
page 286. footnote. Page 286.
Yes, the rule for eviction.
Therefore, this rule has to be followed.
So
It's
what
a- it's a part
this
of the-
rule says, your lordship, is otherwise. Subject is hereinafter provided the divisional forest officer may eject any person from land as a reserve forest in which no person has been allowed to settle other than as a forest villager. So this is a rule which would not be applicable to forest villagers, your lordship. This is the right which the petitioners are claiming. This rule would only be applicable for eviction of persons who have otherwise entered a forest village, but not as a forest village.
Yes,
So perhaps this rule would not be applicable to the petitioners, your lordship.
well, this is a category of two parts. Number one, allotted land is different. Not allotted land is different.
Not allotted land is different. But what this judgment has finally held, your lordship, is that after the Forest Conservation Act has been, because of the operation of the Forest Conservation Act, and after taking into account the provisions of the Scheduled Tribes and other Forest Dwellers Act as well, your lordship, the government of Assam does not have the powers, your lordship, to allot any land within a reserve forest to any person. Now, once that power is not there, your lordship, what this
See,
judge,
there is a legal, legally you will have to explain, number one. That is why I referred to that, it's a pre-independence law of
Lordship.
rules is of 1930.
lordship,
Now, this, you see, there's another statutory, the rules of statutory interpretation is that there cannot be a deemed repeal.
they
Concept
cannot,
of deemed repeal is not there. So if Forest Conservation Act 1980 has come into existence, it has to specifically repeal the state law. Otherwise, state law is saved by the Constitution.
to the extent it is not in contravention with the Forest Conservation Act.
No, that is saved by under 272. So therefore, the 1980 Act has to repeal it. We just see that.
Because the definition of forest, your lordship, as in the 80 Act, your lordship, it starts with a non-obstant clause, your lordship. That notwithstanding anything contained in any other law.
That's why I'm saying, you see, the is a concept of what you call deemed repeal is there, even with a non-obstante clause. So can a non-obstante clause mean that the existing rules are repealed?
No,
When-
it would
when
mean
there's
that the existing rules would have to give way to the Forest Conservation Act. Your lordship.
That's why you see this, the Constitution says that.
Forest Conservation Act 1980, Section 2 starts as restriction on the dereservation of forests or use of forest land for non-forest purpose.
No,
Notwithstanding anything contained in any law for the time being in force in any.
won't help you. Take a break and come back. 72 saves everything, which is pre-constitutional. It can't be a deemed repeal. I'll just take a break and come back. Yes.
These establishment rules, your lordship.
Yes.
Now it will have to be looked from two angles. The
Yes.
first is whether they are in conformity with the Forest Conservation Act and they fulfill the test laid under Article 372, your lordship. Secondly, your lordship, these are rules framed under the Assam Forest Regulations of 1891.
Yes.
So they will also have to be in conformity with the aims objectives of the Forest Regulations of 1891. Now, what the judgment of the coordinate bench has specifically said, your lordship, is
Yes.
that not only are they not in conformity with the Forest Conservation Act of 1980, your lordship, but since the Forest Regulations of 1891, your lordship, do not provide for establishment of forest villages, because the coordinate bench has held, your lordship, that the concept of village forest and forest village are different concepts. Therefore, these rules are also not in conformity with the Forest Regulations of 1891, and therefore no right, your lordship, can be vested in any person because of the operation of these rules.
Yes.
Because
Yes, I'm hearing you.
yes, because first, if I may take, if we come to the test of 372, your lordship, there, your lordship, it has to be either amended, repealed, or altered, your lordship. Now, when the Forest Conservation Act, the section 2 of the Forest Conservation Act 1982 itself starts with a non-obstant clause, your lordship, and not rescinding anything provided in any other law enacted by the state or by the center, these rules will hold the field, your lordship. Then perhaps the Forest Regulations of 1891, your lordship, as well as any rules framed there under, your lordship, will have to give way, your lordship, to the Forest Conservation Act 1980. Because otherwise, if we read the rules as they are, your lordship, the provisions of section 2 will become a nullity.
Yes.
Because section 2 of the Forest Conservation Act specifically provides, your lordship, that not rescinding anything contained in any other law for the time being in force in a state, no state government or authority shall make, except with the prior approval of the central government, may order directing, we are concerned with number 2, that any forest land or any portion thereof may be used for any non-forest purpose. Now, residential purpose is definitely a non-forest purpose, your lordship. So if somebody is allowed to live, your lordship, there, somebody is given a heritable right over a forest over a forest area, lordship, that will definitely be in contravention of section 2. So
See, that's what I'm asking you. Can there be a presumption of repeal? There's a rules, entire set of rules.
the entire set of rules.
Entire set of rules, you have not said that this is, you see, the government is the person which has its own assembly. Correct. It never took, the assembly, the state legislature never took a decision to repeal this being what you call in view of the non-obstant clause of 2. Therefore, the state is not saying. You see, the state has not never come and said that no, this rules is not valid.
But now the judgment of the coordinate bench has said so, your lordship.
We'll have to see how it can be gone, how that can be examined.
Yes, your lordship. And besides, even the rules as they stand, your lordship, even if we do not go into the validity of the rules themselves, even they state that there is no heritable right in any person over the land that they are occupying. Rule 6 of the land specifically says so. Rule 6 of the establishment rules specifically says so. So unless their claim is that the
Just a moment. Yes.
Now, Lordship, for a moment, if we keep the argument of contravention of the Forest Conservation Act 1980 aside, Your Lordship, even then, these rules would have to conform to the aims and objectives of the regulations of 1891, Your Lordship, since they are rules framed under Regulation 72 of those of the 1891 Act, Your Lordship. So even there, the 1891 Act, Your Lordship, provides for establishment of village forests. Village forests where the inhabitants of those villages have certain responsibilities, Your Lordship. Now, since the Act does not itself provide for constitution of forest villages, and this Honorable Court has held that forest for villages and village forests are two different concepts, Your Lordship. Even then, Your Lordship, no right, Your Lordship, can accrue to the petitioners arising from these rules of these establishment rules, Your Lordship. What the Honorable Coordinate Bench has held, Your Lordship, is,
Yes.
if I may just read out the relevant portion. Accordingly, any notification under section 29 of the regulations of 1891 to constitute a village forest would not and cannot include any land under a reserve forest which has already been notified under section 17. Consequently, the concept of village forest as provided in section 29 of the regulations of 1891 and the concept of forest village provided in rule 1 of the establishment rules would have to be understood to be not the same concept or interchangeable with each other. In the context of such conclusion, when we look into the establishment rules, it is noticed that the rules are framed under sections 72E, 74 and 75 of the regulations of 1891. Section 72 of the regulations of 1891 provides for the additional powers to make rules by the state government, which again would have to be consistent with the provisions of the regulations itself, and further to generally carry out the provisions of the regulations. Section 74 provides that every person who exercises any right in a reserve forest or village forest or is permitted to remove any forest produce or to pasture cattle or to practice jhum cultivation in such forest, and every person who is employed by such person in such forest, and every person in any village contiguous to such forest who is employed by the government shall be bound to furnish to the nearest forest officer or any police officer in any information which he may possess as regards occurrence of a fire in or near a forest. Section 75 provides that all money other than fines payable to the government under the regulations of 1891, if not paid when due, can be recovered under law as areas of land revenue. A reading of section 72E of the regulations of 1891 makes it discernible that it is an additional power to make rules consistent with the provisions of the regulations and generally to carry out the provisions of the regulations. When the regulation itself does not provide for the concept of forest village, any rules that may be framed in exercise of the power under section 72E cannot be understood to be providing for creation of a forest village. But section 74 refers to a person who exercises any right in a reserve forest or in a village forest, or who is permitted to remove any forest produce or to pasture cattle or practice jhum cultivation in such forest, or who is employed in such forest, and provides that if such person possesses any information in respecting the occurrence of any fire or in or near such forest, or the commission or intention to commit any forest offense, such person shall, without any delay, furnish the information to the nearest police officer, forest officer, or a police officer. Dominant purpose of section 74 is that the information regarding occurrence of any fire in or near a forest or commission or intention to commit any forest offense is available to any such persons referred therein. They are bound to furnish the information to the nearest forest officer or police officer. While describing the persons referred therein, mention is made of such persons who may exercise any right in a reserve forest or a village forest, or who may be permitted to remove any forest produce, pasture cattle, or practice jhum cultivation, or who is employed in such forest. While describing the persons mentioned therein, no reference is made of any forest village, though the rights mentioned therein may be over a reserve forest or a village forest. The term village forest in section 74 would have to be understood to be a village forest under section 29 to be of the regulations of 1891, and not to be any forest village within the reserve forest. From the provisions of section 74 also, no conclusion can be arrived at for carrying out the provisions of the regulations of 1891, the state government has been authorized to frame any rule providing for the creation of a forest village. Section 75 of the regulations of 1891 is for providing the manner in which any money due to the government in respect of any forest produce or for any purpose under the regulations can be recovered. Section 75 also does not provide for any such provision in the regulation for creating a forest village within a reserve forest. From a conjoint reading of section 72E, 74 and 75 of the regulations of 1891, it is discernible that the additional rule-making power of the state government does not empower for creating any forest village. From such point of view, although rules 1 and 2 of the establishment rules refer to forest village or establishing a forest village within the limits of any reserve forest, it cannot be read to be a village established or created within a reserve forest, where the persons who may be in occupation of such village would have the rights or entitlements as may be available to the persons in occupation of otherwise a village simplicity. Now, this judgment was rendered in respect of petitioners, Your Lordship, who are some of the petitioners are co-residents of the present petitioners in the same village, Your Lordship. The prayer made in the writ petition, Your Lordship, curiously is
Yes.
the prayer is twofold, Your Lordship. It starts at page number 22 of the writ petition. Firstly, for setting aside the eviction notice issued by the DFO. But second prayer, Your Lordship, has been very curiously drafted, where they have said that land allotment certificates should be issued to them, Your Lordship. What they have said is mandamus should not be issued directing the respondent authorities not to give effect to the notices and verbal orders issued by the DFO Longai Division to the petitioners to vacate their lands and houses at NS so-and-so village, so-and-so village, and so-and-so village under the Longai Reserve Forest, and or to allow them to reserve in so-and-so village, so-and-so village, and so-and-so village without any hindrance by issuing repeat land allotment certificates under the relevant law. So even they have admitted, Your Lordship, for a moment, if we assume that these rules have been properly framed and there is in fact a right accruing up to them by these rules, Your Lordship, even they admit that as of today, since the rules particularly say that there is no heritable right in any person, Your Lordship, there are no land allotment certificates in their favor. If I may take Your Lordship to Rule 6, Your Lordship, of the establishment rules. Because firstly, Your Lordship, Rule 2 says forest villages are designed for the purpose of providing a source of suitable local labor and for forming and maintaining plantations and tongias, and no castes which are not habituated to living and working in the forests are eligible for admission. Divisional forest officers may admit new entrants to existing forest villages in accordance with the executive orders of the conservator. Now, Rule 6 says, Your Lordship, so the purpose of establishing a so-called forest village, Your Lordship, is clear. It is for labor used for maintaining plantations. Now, Rule 6 says, on the decease of a householder, the name of his male heir will be registered as a forest villager if he is considered by the divisional forest officer to be suitable in all respects, or in cases where a daughter is the heiress, the name of her husband should be recorded as the householder if he is suitable for employment as a forest villager. This is important. The name of heirs who are minors will be recorded as forest villagers when they become fit for work, or in the case of females when they marry husbands suitable for employment as forest villagers. So employment is the key word, Your Lordship. But nothing in this rule shall be held to recognize any heritable right in land allotted to a forest villager. So as of today, from their own prayer, it is discernible, Your Lordship, that there is no forest allotment in their favor, because that is their second prayer, that they should be allowed allotment certificates. And secondly, nowhere in the petition have that said that they are employed under the forest department, or they are involved in maintaining plantations, Your Lordship. That is not their claim.
That won't help you.
No, this is
This general rules.
yes,
Come to page 271.
yes, Your Lordship.
271 of that book.
I have otherwise the rules are. Yes, Your Lordship.
Yes. 9 at 271. Each adult forest villager shall, if called upon.
Render 20 days labor per annum at the rate of
If
wages.
you call them, they will give. If you don't call them, they will not give. So it
That
doesn't
is-
help you.
Again, besides,
Because once Mr. Bhattagar has shown me the rules, I have flipped a part of it. I don't.
no, what I am trying to say to Your Lordship is, as of today, there is no allotment certificates in the. Suppose if we do not require, we may not call upon Your Lordship. And if we do not require labor, Your Lordship, that further means, Your Lordship, that they also do not have any right to decide within the reserve forest.
You see, come to page 40 of the writ petition.
Lordship. Page 14, Your Lordship.
40.
4-0. Lordship. Lordship.
Now you see, you read this entire part, you will find that there are references to Rupit land under dark number 50,
Yes,
public 2, correct?
yes, your lordship.
Now, just before the signature, there is a note. The relevant land records, including Jamabandi register, should be collected accordingly.
Quoting reference to
This
this
is-
office order as authority.
So that means you do maintain, as per this chapter 7,
Yes, your lordship.
you do maintain a register
Yes, sir.
where the names of persons who are temporary forest villagers, they are entered,
Yes, your lordship.
correct? So having followed this rule, the state forest department cannot come up and say that, well, these rules what you call has no meaning at all.
Now, your lordship, today, your lordship, I'll be bound by again by the judgment of the coordinate bench, your lordship, because that is the law holding the field, your lordship. When the judgment has specifically said, your lordship, perhaps, your lordship, we should read the entire judgment then. Because in that petition also, prayers were made for issuance of Jamabandi certificates to them, besides a second prayer not to evict them. Both the prayers were taken care of in that judgment, your lordship. So if we can take your lordship to the judgment, your lordship, the entire thing will make it. After this. Can we read from para 31 onwards? Your
It
lordship,
doesn't
not
help me.
just-
I have to issue a notice, it doesn't help me. So number one, I'm not deciding the, without issuing a notice, I'm not deciding a writ petition right now. That is number one. Unless you concede that, well, without affidavit, I'm ready to argue the matter. So therefore, if you do that, if you do that, then it's okay. The second part is you see, I can't just what you call omit reading 372 and say that the pre-existing laws could have been so easily what you call held to be what you call these rules can be said to be contrary to 1980 Act. Because you see, virus, if I have to, why I said that your concession is required, because normally to consider the virus of the Act, I'm required to give notice to the Advocate General.
Lordship.
Because these rules I have to read down by saying that it is contrary to 1980 Act. For that, I can't, unless you as a departmental counsel concede, then I may perhaps deal with the matter. Otherwise, I am statutorily required to give notice to I'm legally required to give notice to the Advocate General. The rules, what you call, a tacit challenge is made by the state against its own rule.
But lordship, perhaps that issue, your lordship, about the validity of the rules has already been settled, your lordship. Perhaps that issue of validity of the rules and its conformity with the regulations of 1891 and the Forest Conservation Act, that has already been settled, your lordship. Perhaps that issue may not be gone into in these
Yes.
proceedings.
It will be an issue which has to be decided by the court, because you see, I issue decided without referring to the provisions of law. But again, what you call, there can be two ways to look at it. Number one, it can be said that it is what you call sub silentio.
Sub silentio.
How can a validity of the act be said would cease to exist merely by interpretation of the court without referring to 273, 372 at all? That's
370.
why I said, unless you concede to that,
Perhaps without an affidavit, even I'll perhaps not be.
if you concede saying that these rules do not exist for all point of time, and so therefore the second point which I have to decide is whether there can be even by a concession, can there be a what you call deemed repeal? Deemed repeal of these rules.
May I then make a prayer, your lordship? Can this, since I would not be able to make such a concession, your lordship, since I'm not, if your lordship may have it on day after tomorrow, your lordship, I'll request the additional Advocate General to be present, your lordship. Perhaps he may be able to make the concession, your lordship.
Then I frame this question.
Yes, that is the correct, because at my, in my position, I would not be able to make that concession, Your Lordship. Perhaps
That's
he may be
okay,
able.
that's why because you'll have to address me on the what you call the validity of this rules vis-a-vis Article 372.
Lordship may have it day after tomorrow, Your Lordship. Then I'll request him to be present.
But the notice still also for I'd say both the Advocate General or the Additional Advocate General, whoever.
Lordship,
So because notice must go to the Advocate General,
Lordship,
but I'll make it optional if
Lordship.
Additional Advocate General wants.
Lordship.
But besides Butterwood and counsel for the petitioners, as well as Mr. K.V. Patak and standing counsel for the Forest Department, appearing for all the respondents.
For all the respondents.
All the respondents. Next para. At the outset, the learned departmental counsel has submitted, has referred to the decision, judgment and order dated 9/5/2023 passed by the coordinated bench of this court in WPC 4775 of 2022. And it is submitted that in this said judgment, this court had interpreted the inverted commas village forest as well as inverted commas forest village, and it has been held that the establishment of village forest would not and cannot include any land under reserve forest which has been notified under section 17 of the
Assam Forest Regulation.
Assam Forest Regulation. What is the year?
1891.
1891. It is also submitted that this court has also interpreted that the power under section 72 within bracket E of the 1891 regulation cannot be understood to be providing for creation of a inverted commas forest village. Full stop. Per contract comma, next para, per contract comma. Just add there. So it is also submitted that the petitioners in the said writ petition are co-villagers of the village of the petitioners in this present writ petition. And therefore, as the inclusion of names of the petitioners in respect of the petitioners in the said writ petition in respect of their land located inside reserve forest in Jamabandi was held to be unacceptable, the petitioners would be, the case of the petitioners would be covered, would be squarely covered by the ratio laid down in the judgment dated 9/5/2023. Next paragraph. Per contra, comma, the learned counsel for the petitioners has opposed the submission made by the learned departmental counsel by submitting that the rules for the establishment and control of forest villages, which is contained in chapter 7 of the general rules framed under the Assam Forest Regulation, was a pre-constitutional rule which was framed under notification number 4631-R dated 6th December 1930 under section 72 within bracket E, 74 and 75 of the regulation, and that rules regarding eviction from the reserve forest and rules for that the provisions for eviction from reserve forest and rules for eviction from reserve forests was inserted in exercise of powers conferred under section 72 within bracket C of the Assam Forest Regulation, wide notification number capital FRS 153/71/89 dated 21st May 1973. First of all, it is submitted that the judgment and order dated 9/5/2023 passed in WPC 4775 of 2022 would not come into the way of this court to adjudicate the present writ petition because because of the judgment passed by the division bench of this court in the case of Anchar ANCHAR Ali and others versus the state of Assam and others, reported in 1987 SCC on O capital line L capital on line GAU 115 equivalent to within bracket 1987 to GLR 421 was not placed for consideration of the court when WBC 4775 of 2022 was decided. And that the provisions of section 3 within bracket 1, bracket 2 H of the scheduled tribes and other traditional forest dwellers within bracket recognition of forest rights, bracket closed, Act 2006. But don't say this section, the scheduled tribes also was also not considered while deciding this writ petition. First of, in the said context, it is submitted that the Government of India, Ministry of Tribal Affairs, has initiated a step for conversion of all forest villages, old habitations, unsurveyed villages, etc., into revenue villages under section 3 within bracket 1 within bracket H of the scheduled tribes and other traditional forest dwellers, bracket close, recognition of forest rights, bracket close, Act 2006. So hence it is submitted that before carrying out eviction of the petitioners, the petitioners would have a right to represent before the authorities to show that to show that they have been residing within the forest land for more than 75 years. What was that? 75 years, Mr. Waterworth? 75 or 3 generations, or 3 generations, as provided in the
Section 2.
section 2 O of the said 2006 Act. Next paragraph. In view of the rival submissions made at the bar, the court queries as to whether pre-constitutional rule can be deemed to have been repealed, or the said rules are saved by operation of Article 372 of the Constitution of India, has to be examined. First, therefore, taking note of the judgment rendered in WBC 4775 of 2022, this court is inclined to examine the matter as regards validity of the savings or implied repeal of the rules for the establishment and control of forest villages which was not a fact an issue in the previous writ petition. Hence, the court is inclined to issue notice on the Advocate General and obligor Additional Advocate General for the state, who is assigned with the matter relating to forest department to address the court on the said point. List on.
Can it be on the 20th, Your Lordship, next Tuesday?
20. Okay, 20. 6/20/23. Next one, Departmental counsel shall provide a copy of the writ petition, to the Advocate General or the Additional Advocate General as the case may be. I'm returning you this. You place it on the next date. Mr. Patakul, your document I'm returning, you can place it on the next date.
Publish.
We prepared on this Article 372, its interpretation. Savings and other things. Yes.
Lordship, in this case, Lordship, I am praying for accommodation for today, your Lordship, only for today, Lordship. Mr. Kane Chaudhary, yes, he reached yesterday at Guwahati very late at night, Lordship. He could not be able to assist you
It depends
today.
on how stoutly Mr. Tiwari opposes.
My lord, if the prayer is allowed, today will be the 8th time unlucky. If this prayer is allowed, today it will be the 8th time unlucky. On the previous occasions, for one reason or the other, matter could not be taken up. It didn't reach on many occasions.
That's actually.
Another difficulty is Justice Manish Chaudhary cannot hear this matter. He recused himself because of personal difficulty. So my lord's bench is the only bench. And here is a case, my lord, the downstream of the river Subansiri, the construction of embankment has been stayed. It's a public interest involved, it's a mega project. So my lord understands the seriousness of the situation.
I appreciate that, Lordship, but there are.
And my lord, may lord, for their benefit, my lord, I may place my arguments because at least they have their writ petition, they have the interim order. I'll press my stay vacation application by way
No,
of,
that would mean parted, it's a very dangerous proposition.
my lord, because in any case, in one day, possibly matter may not be
No, that is
concluded.
okay, but if both of them start arguing, then I understand. But to,
Because I begin today, I complete my part. As and when Mr. Chaudhary is present, he can give a reply.
no, without opening, how can you give a reply?
No. Today, my lord, I'll complete my part at least by evening. In both the cases. They are connected matters.
There are some issues that.
Or my lord, my London
But
friend,
then, since urgency is expressed and it's a mega project,
I
they
appreciate
are
that,
not
but
delayed,
there is-
we'll take it up day after tomorrow.
day after the, tomorrow may not actually have a partner matter in Itanagar. I have to leave tomorrow. So the Thursday, Friday, I'll be there. Then next week again, I'm here.
Thursday, Friday, day after tomorrow.
Then 20,
20, yes, my lord.
20.
Or may not,
Okay.
let it begin on Monday, because Monday it may not be over, so at least Tuesday.
no, Monday I have unlimited matters.
Oh, yes, and Tuesday also may not.
Well, Tuesdays Thursdays I'm reserving for this hearing matters.
Tuesday, just now I heard Article 372 proposition will come into play. One
Yes,
of the
yes.
matter.
Because I can't accommodate on.
Naturally, I understand. My lord is also is under compulsion.
Okay, I have a apology prayer, Lordship, on 20th Lordship, there may be a difficulty on my lord, my senior
No,
Lordship.
we'll have to start. You can file a
Yes,
written
Lordship, I
argument.
request the Urgency, Lordship, it's a quite an urgent matter, Lordship.
No, I'll
Any other
provide, I'll provide that if, no, you see, please consider my predicament. After this 20, I've got only 1 week.
Yes,
then there's a
Lordship, the
vacation.
last week will be very burden.
Then there's a vacation.
Burden, Lordship.
Then there's a vacation. Then I have to recuse myself after hearing the matter. I can't keep a matter parted for too long.
Gets things.
No, we'll provide that if you can't make an oral argument, you file a written argument.
Yes, that would be better.
Because if you see, I'm bound by Article 41, sorry, Section 41A of the Specific Relief Act. It says that
That's true, Lordship.
when,
Infrastructure projects cannot be.
projects, I can't.
And in the high
Yes,
speed
sir.
case, my lord, the Supreme Court pointed out, in the high speed case, the Supreme Court pointed out in 2022 6 SCC that in such cases, other side may be put to notice that is because of stay order, there is a delay in the project. In the event of they losing the case, heavy damages will be imposed. This is the observation of Supreme Court in the light of Section 41 of the specific relief. So my lord, let it be on Tuesday, as my lord suggested. We'll go by that.
Tuesday, some difficulty, Lordship, subject to the.
I begin at least. Let me begin on Tuesday.
Then we permit him, we'll put them to notice if we are giving two options. We permit Mr. Tiwari to begin, at least it will start.
Lordship, we have actually, I have impression, Lordship, we have considered in for Monday, your Lordship. So because on Monday, it can be start, your Lordship. Lordship, subject to your Lordship's argument.
No, Monday I
Monday
can't
is
stop
Lordship.
motions and then start hearing hearing matter.
Motions, it will take some time. But
For that,
hopefully
in
it starts
keeping,
at Monday,
no.
Lordship.
Mr. Das, for because of that, I would create a precedent by requesting you to obtain the what you call consent of the president of the bar that I don't take up motions and I take up
The
hearings.
motions are more urgent, your Lordship. I agree.
But that would be in what you call transparent manner. At least before the media, I will not be hanged.
No, Lordship. That is not possible.
See, either you take the no objection from the president of the bar, it's okay. But we'll have to hear. I can't postpone it if a request for early hearing is being made. Mr. DG Das on the council for the petitioner raised for an adjournment. First of the prayer for adjournment is vehemently opposed by Mr. P.K. Tiwari and on council appearing for respondent numbers 2 to 5 by submitting that because of the pendency of this petition, the construction of a mega dam,
Embankment in the
Yeah.
downstream of River Subansiri, which is part of the project.
construction of
Embankment,
embankment in respect of downstream
downstream of River Subansiri.
of river Subansiri is state, which is affecting public interest.
And it is part of the project, mega project.
Being part of a mega hydroelectric power project. First of all, it is also submitted that
My lord, they incorporate this, para 48. It's
that he
para 48. This one.
that in the event the petitioners do not want to commence the hearing, he may be permitted to make his reply, make his submissions for respondent numbers 2 to 5. First of all. First of all, the learned senior counsel for the respondent numbers 2 to 5 has also pressed paragraph 48 of the case of National High Speed Rail Corporation Limited versus Monte Carlo Limited, MONTECARLO, one word, Limited. Within bracket 2022, bracket 6 SCC 401. And it is submitted that the petitioner should be put to notice that in case the petitioner loses and there is delay in execution of the project due to the proceedings initiated by the petitioner, or the petitioner may be saddled with damages caused for delay in execution of such projects. Full stop. Next paragraph. In view of the urgency expressed, it is provided that prayer for adjournment shall not be considered on the next date of listing. However, either side who is praying for an adjournment, who would be praying for an adjournment on the next date, will be permitted to file written argument in lieu of oral argument. And the matter would not be adjourned on the next date of listing. Oh, no. First of all, the petition is also put to notice for cost in the event the petitioner loses the matter. Next paragraph. List on now till the date.
We are ready for 15 also, madam.
15 is not available.
Yes, madam.
So next, when do you want to do?
Next. Because on 20th, my lord, my senior Mr. K.N. Choudhury may not be available on 20th.
On 20 will not be available. So 21st.
Yes, my lord, 21st.
Oh, sorry, this is not 21st, 22nd then. 22nd.
Though I have other cases, but I'll make myself available here, my lord, for this event.
We never doubt you don't have cases.
My lord,
You want us to
in
doubt?
fact, No, my lord, it's not that, but
No.
there are other pressing matters, but even then, for this case, I'll be here.
Yes. So written notes if physical argument is, oral argument is not made.
Lordship, not in place of DJ Das Lordship, my serious then maybe.
Okay, Mr. DP Bora.
My lord,
D-
interim
D-
order may be continued.
Okay, interim order stands extended till the next of this thing. So however, further continuation of the interim order shall be subject to for the orders that may be passed on the next date.
টাইম লৈছিল 6 তাৰিখে এসপ্তাহ গতিকে হৈ গ'ল এইটো সপ্তাহত মাতিব লাগিব এজনটো আজি মাতা হ'ব First on 15/7/22. For supply of furniture to this Adarsh Vidyalaya, Dolgaon. Now, my lord, that tender had to be cancelled due to insufficient qualified quotations, my lord. That 15/7/22 tender was cancelled. Subsequently, my lord, on 20/10/22, the principal invited fresh tender, my lord. Now, my lord will take note of one aspect herein. In the NIT dated 15/7/22, my lord, the furniture which was sought to be procured, my lord, where it was indicated it should be good quality like Godrej, Wipro, Zuari, or Federal, etc. But in the subsequent tender, my lord, that requirement from specified brand was done away with. Now, in the tender process, my lord, the petitioner, along with 6 others, participated in the tender process, which was issued on 20/10/22. And the comparative statement was also prepared by the authority on 3/11/22. Now, my lord, on 15/12/22, the petitioner received a communication which is dated 14/12, whereby, my lord, the petitioner was asked to provide sample of the furnitures which you would like to supply. Now, my lord, the 17 and 18 were the only working day. 19 was a holiday. So effectively, my lord, he got only 2 days for providing the sample.
Yes.
Now, my lord, initially thereafter, my lord, this petition was filed with the prayer to issue, and it so happened, my lord, the petitioner emerged as the L1 bidder in the tender process. Now, therefore, my lord, since the tender was not being finalized, he instituted this WPC 8353 of 22. Basic prayer was to, my lord, to issue a work order as petitioner was adjusted as the L1. Now, an interim order was passed, my lord, in that writ petition. Yes, on, my lord, 21/12/22. Then lordship will kindly come to paragraph 6 of the order, my lord. Those are 7. Till respondent number 5 does not disclose about the status of the various bidder, or till next returnable date, whichever is earlier, no work order shall be issued by the respondent number 5. In other words, once respondent number 5 declares the status of the various bidder, it will be open to them to proceed with the procurement in terms of the NIT rated 2010. It is also provided that respondent number 5 shall inform the bidder about the status of their bid, pursuant to tender register report to maintain transparency. So why not this?
Yes. You're getting the voice? Now you're getting the voice?
Little, I mean, oh my God. They're getting, but I don't.
I'm hearing you without speaker. There's some technical issue, some noise is coming and they are unable to trace how it is coming.
Now,
You are getting the voice now? Yes, we'll have to endure till the technical people come. We'll have to endure.
yes, yes.
On, I hope. Speaker is on, Mr. Chaudhary. Now also you're not getting? No. Yes. Technical people are coming. In the meanwhile, you can start.
I can start
Ah,
my, yes.
Technical people are coming to look into it.
My lord, after this order, dated, my lord. 20. For 5, that is the principal, my lord. Filed an affidavit. The filed on my 7/1/23.
Yes, I'm sorry. I'm sorry, it's disturbing.
No, it's okay. Now, can I proceed, my lord? Yes. Your lordships kindly come to the affidavit, my lord, filed by respondent number 5 on
Yes.
27/1/23.
Yes.
Now, please come to page 10, annexure A of that affidavit. My lord, the MJ Enterprise is the petitioner in the other case, who is represented by Mr. Nair. And my lord, JMK is the petitioner before lord. Now, physical inspection team report on furniture sample for others of Vidyalaya, so and so, provided by MJ Enterprise and JMK Enterprise. I have already indicated, my lord, only 2 days time was given for supplying the, my lord, sample, for providing the samples. Now, because the paucity of time, my lord, some components could not be given, my lord, which was in the process of being given. But nevertheless, my lord, they made this inspection. They say on the right hand, extreme right hand column, my lord, under GMK, frame structure of desk cum bench are found as per specification, but board not fitted properly with structure, powder coated, not found in the sample. Frame structure of desk for teacher is found without drawer. Worktop is not fitted properly in the sample. Powder coated not found during our verification of the sample. Now, regarding the other sample not provided, top board is not fitted properly. Anyway, my lord, it was only a sample. My lord, having regard to the stand taken by the principal, an order was passed by the honorable court, my lord, on 31/3/23. Please have a look at the proceedings of 31/3/23. My lord will kindly come to the first subject. Have you lots of time?
Yes.
The matter pertains to the matter pertains to a tender process initiated by the NIT dated 15/7/22 for supply of school furniture for the respondent number 5 school. It is the case of the petitioner in the first NIT, though the deed of the petitioner was found to be unwashed. The same was cancelled, whereafter another process was initiated by notice dated 20/10/22. The case of the petitioner is that in the second process, the bid submitted by the petitioner emerged as L1. However, there is a note by an authority recommending rejection of the bid of the petitioner on the ground that supply of samples were of inferior quality. The learned counsel for the petitioner submits that apart from the fact that very less time was granted for making the samples for supply, making supplies of the sample, the recommendation is not based on, not on the basis of quality, but certain lack of fittings which could not be done because of constraint in time. On the other hand, whatever the learned counsel for respondent number 5 cited, the authorities were competent to take the decisions are yet to take such decisions, and matter is only at the stage of a recommendation by the ADC. Be that as it may, this court is of the opinion that the dispute may not be required to be adjudicated in view of the direction which is proposed to be passed. The court is of the opinion that petitioner be afforded with another opportunity to place the samples of supplies which he proposes to make within a period of 10 days from today, and there will be a fresh inspection assessment of this supply made and a decision will be taken. It is needless to state that such decision be taken independently and fairly, and the outcome may be informed to this court by the next date fixed. In view of the above, the petitioner may make supply of sample within the period stipulated above, and decision be taken thereof within a period of 2 weeks thereafter. The matter be listed for consideration on 3/5/23. The sample which were supplied earlier by the petitioner are required to be returned to the petitioner if not already returned. Interim order passed earlier to continue till the next date of listing. My lord, pursuant after this order, my lord, by an order dated 19/4/23, work order was issued to the petitioner. So that way, my lord, the writ petition stands answered. Writ petition, the work order is issued. Now what had happened, my lord? After that, the other writ petition has been filed by this NJ, my lord, suppressing the fact about this order. There is absolutely no mention in the writ petition about, my lord, this order. As if, my lord, there was a restraint order. The order never said that order cannot be issued. All that was said was within 10 days time, we will provide the my lord sample, and thereafter they will take a call, and whatever decision is taken, it will be placed before the honorable court on the next date of listing, that is 3/5/20. Read that order once again, my lord.
No, not required.
Yes, yes. So now, my lord, the other writ petition has been filed. There is, my lord, challenging the work order dated 19/4/23. Now, in that, an order has been passed. If your lordship kindly take the file of the other. 3/5/23 order, my lord, because in terms of the earlier order, the matter was listed. Now, this is the order which the honorable court passed. The challenge is with regard to an IT dated 21/10/22 for supply of furniture to the Adarsh Vidyalaya, Dalgaon. Petitioner in WPC number so was found to be L2, while petitioner in WPC was found to be L1. In the comparison statement made with regard to furniture sample submitted by two parties, it was found that the petitioner in petitioner number 2189 had supplied samples for all items, while the petitioner in so-and-so had made furniture supply sample only for desk cum bench and for teacher's table. However, no sample has been provided for 10 out of the 15 furniture samples to be submitted. Accordingly, recommendation has been made to accept the tender submitted by petitioner in WPC number so-and-so. The petitioner in so-and-so stating that he had been given only 2 days time to submit furniture sample, and this court in his order passed in WPC directed respondents to accord another opportunity to the petitioner in WPC number 8353 to place the furniture sample which was proposed to be supplied in terms of the NIT. Subsequent to the above, petitioner in WPC supplied the furniture sample, and the same being approved, work order has been issued in favor of the petitioner so. The grievance of the petitioner in WPC 2189 is that this court in its order passed in WPC had directed the decision to be taken for supply of furniture was to be made fairly, and this court was to be informed of the same. Petitioner in WPC number so submits that the said decision has not been informed to this court as directed in his order passed. Mr. Bordhatul and counsel appearing for the school shall produce records on the next date. He shall also give a copy of the document submitted to this court today to Mr. So-and-so, senior counsel for the petitioner. As it has been stated by Mr. Bordhatul that desk and bench had not been furnished by desk and bench has not been furnished by the petitioner in so-and-so, the supply of the said furniture shall not be made till the next day. So that I could not understand few things from this order. First come first, my lord. Now, my lord, if petitioner in 2193 is aggrieved by the order dated 31/3/23, they should have preferred an appeal. That order has still there has not been challenged. Pursuant to that order, my lord, now all these actions have been initiated and the petitioner was found to be L1. Now, what prevented the principal of the college school from placing before this honorable court the fact that on 19/4/2023, settlement order has already been made because subsequently he provided the sample and he was found to be a responsive bidder. So what is the fault? What is my fault, my lord? Now kindly come to this sentence, the grievance, kindly see that. The grievance of the petitioner in WPC so and so is that this court in its order dated past had directed that decisions to be taken for supply was to be made fairly and this court was to be informed. Who will inform, my lord? My clients cannot inform. It will be informed by the respondent number, the principal. Now, principal was represented in on that day. Mr. Bothakur learned it appearing for the school shall produce on what day, on that day he should have informed the court. But because he did not inform, that cannot form a basis for passing an interim order against me when I am otherwise adjust to be, my lord, substantially responsible. And that order of the learned single judge, that is 31/3/23, that has not been assailed by anybody, that has attained finality. If any wrong has been committed, then the learned single judge has committed by passing the 31/3. But otherwise, his grievance is what? Now, why is he, my lord, correlating with those that I did not supply this and that? Because it is the same of satisfaction of the learned single judge is, my lord, kindly. Subsequent to the above, just one sentence above that, petitioner in WPC supplied the furniture sample and the same thing approved, work order has been issued in favor. In my humble submission, my lord, because of this order, my lord, I am not now, they are not accepting furniture. Others also merit what is there, my lord. And my lord, what is the right of the petitioner in the other case? Under the CBC guidelines, my lord, L2, there cannot be any negotiation with L2. If at all there is any negotiation, it can be only with the L1. What is the scope of making somebody an L2, my lord? Is it a DGSMD contract? Is it a rate contract? There is no scope of, it can be so happen. In terms of price, you are L2. But when it comes to awarding the contract, it has to be the L1. As an L2, we do not have any enforcement. So what is your enforceable right in this? Yes.
No,
And in that case, my lord,
do I not have a choice? Supposing I have called a tender for the pen. Now, the pen, you will use only which suits you. So it's not a question of the, what you call the price alone,
Therefore-
the quantity, the
therefore,
quality
my
itself.
lord, I follow the lordship's point. Therefore, on 15/7/22 tender, they specified the make. That it should be either Godrej, it should be jewelry, it should be Wipro. So in the subsequent tender, that has been removed. Now you yourself is inviting deterioration in the quality. And then it was there. In that tender also, I was L1, my lord. On the LS ground, that there was less competition, that tender process was amended. And the first tender process was done. Earlier also I was L1. So therefore my humble submission is, but that is very simple. By giving the work order, my WPC stands answered. So perhaps there I cannot even need to that. And when it comes to attacking my order of, order at the instance of the party who is L2, so what is his enforceable right?
I've not even heard, Mr.
My lord, I'll take my lord.
Well, one more thing, my lord. In the WPC 2189 of 23, there is no whisper in the petition about order dated 31 feet. There's absolutely no whisper. So to that extent, there was suppression of facts.
My lord may come to page 35. My lord, when these samples were called for by that letter,
Just a moment. Yes.
My lord may come to page 35.
Huh.
After that notice of 14, 12, 22 to give samples, I'll show my lord how many samples are required and how, what is the requirement we are finding. If my lord comes to page 35, my lord would find here that there is a comparison table of the goods that were supplied, samples that were given. My lord comes to the bottom. There is, my lord, signature with designation in the middle, my lord. Just to the left of that, it's the petitioner. And my lord will not find even a whisper, because I am also there. My goods were found to be proper. The samples which I supplied were all found to be proper. Yes, there were some complaints. My lord has got it. In spite of this position, my lord, this was not even highlighted in the report. And I was not made a party. Now, after this, the matter went to the authorities and they were in the process of issuing my lord, work order. It is in that context that on 20th, this repetition was filed here. 20 or 21st, the repetition was filed. Now, my lord comes to the tender, which my lord would find starts at page 26.
26,
my lord. It's my lord 2010-22. My lord has got it. This is the tender inviting my lord, which is there in annexure 1. I'll have my lord's attention at page 27, annexure 2. That's the terms and conditions. My lord will have clause 11. Wherever indicated, sample may be furnished at the supplier's expense unless otherwise specified. So basing on this, my lord, at page 32, therein again, my lord would find page 32, 14, 12, 22. And admittedly, the respondent, private respondent, my lord, is the L1.
But Mr. Nair,
Gotcha.
you see, the issue is that this court passed an order rightly or wrongly of 31.
I'm coming to that. I'm coming to that only, my lord. I'll handle the suppression part. I'm coming to that. With reference to the subject cited above, I have the honor to inform you that as per instructions from the Honorable Deputy Commissioner, you are hereby directed to provide samples of furniture of all items as per specification dated on or before 19/12/22. And here, the person at D, top, my lord, is the petitioner in 2189, who was at that point of time, my lord, L2. So the plea now that is being taken, that the L2 should not have been called for supply of samples. This was known to the petitioner in the first case on 14/12, if not from before. And before the rates were opened and my firm was L2. Still, I was not made a party and no challenge was made to this. Then my lord, the goods were supplied. Now what happens, my lord?
Yes, just a moment.
And my lord, page 35. I'll just have my lord's attention back. Herein, in pursuance of that 1412 letter, samples were submitted. And my lord, both of us, L2 and L1, both were signed that one. Still, when they came before this honorable court, they did not make me a party, my lord. No notice was given to me. Now what happens, my lord? Now, my lord will have page 36, 11/4/23. my lord. I get a letter from the principal.
Yes.
My lord will have the body of that letter. With reference to the subject cited above, I have the honor to inform you that there will be fresh inspection, assessment of furniture samples dated 12/4/23 at 11 AM at school premises. You are hereby informed to attend tomorrow. So the date was one day ahead. I was to appear the next day. And my lord will not find any reference here about the High Court case. my lord. In page 36. So I can't presume what I did, my lord, page 37. My lord will note the words fresh inspection / assessment. 2 words. Then I write at page 37. I am surprised to receive your above letter in connection to inspection of so and so, dated on so and so, through samples of the furniture was submitted by both bidders long back, including the undersigned, and the same was duly inspected. And to that effect, inspection committee also observed that the sample submitted by JMK Enterprises was of inferior quality. Under such circumstances, inspection of samples furniture already submitted does not at all arise. Further, I have never been informed to submit fresh sample furniture again for inspection schedule on so and so, and therefore inspection schedule apparently appears to give an undue favor to so and so, who has earlier submitted inferior quality furniture, and thus the same is highly arbitrary. I therefore request you to keep in abeyance inspection schedule on so and provide me information as to why fresh inspection is warranted for inspecting the same samples already inspected and assessed. Then, my lord, I come to know on 19 that a work order is issued. I tried to get a copy of that work order given to the private respondent. I could not. I filed this writ petition. Now, my lord, after filing this writ petition, if my lord can have the order dated 21/4/23. My lord, here, the second paragraphs are with regard to the grievance. Then, my lord, so and so Learned Singh Council has, however, pointed out that the aforesaid direction appears to be in compliance of an order dated 31/3/23 passed by this court in WPC number 8353/22, which was instituted by the other bidder, and in that case, the present petitioner was not a party respondent. The court has been informed that the said case is directed to be listed on consideration on 3/5/23. List this case along with WPC number 8353/22 on 3/5/23. Any action taken in this regard shall be subject to further order that may be passed on 3/5/23. So my challenge, because my lord, I did not know. When before we moved, we got to know about this information from the official respondents. I immediately placed that. Mr. Goswami was in the court. When they posted, he was also called, my lord, that there is a matter. I said, fine, let both the matters come up together. Accordingly, the matters came up together. There were adjournments. Thereafter, my lord, Justice, it was listed before What is it? Which order my senior has read, my lord, Justice Michael, because they were also there. The petitioner in both the writ petitions, including me, were there. And thereafter, this honorable court passed an interim direction that what supply you have made, you made, but that will be, don't make further supplies, we will consider the matter. That is how the matter is before your lordship. So there is no suppression on my part. You deliberately did not make me a party. My lord, if I was made a party, when my lord issued the notice on the first day, a copy would have gone to me. I would have come up before your lordship and I would have contested the matter. That opportunity was not given.
No, you see, but there is an order of 31.
I'm sorry, what is that order? That order has been clarified by the same court. At page 3, my lord would have that order dated 21/4/23. After noting my grievance in the second paragraph, third paragraph, quote, the last paragraph, my lord, any action taken in this regard shall be subject to further order that may be passed on 3/5/23. On that day, matter was adjourned, and thereafter subsequently, when the matter came up before my lord Justice Michael, the records were also there, my friend was there, the respondents were there, and this order was passed. So my lord, if my lord goes through that order dated 31/5, which my lord would find at page 52 of my writ petition, that file of the writ petition, it's in the form of an affidavit, starts at page 51, my lord.
That observation you were reading was on which date order?
The order was of
21/4.
21/4. Thank you. I had a copy, my lord. but some- Send me. Oh, no, sorry. Both the cases, my lord, were tagged together and that order was passed, my lord.
So 21/4 does not have that observation,
What, my lord?
subject to further orders.
No, subject to further orders is in that order of my lord. 21/4, my lord. Yes, my lord, the last line.
Oh,
Any
achha.
action
Yes, yes,
taken in
yes.
this regard
Sentence.
shall
Yes,
be
yes, yes, last.
subject to further order that may be passed on 3/5. Now, my lord would come to that order of 31/3/23. my lord. My lord has got this second paragraph. my lord. The matter pertains to a tender process initiated by an NIT dated so and so for supply of school furnitures for the respondent number 5 school. It is the case of the petitioner that in the first NIT, though the bid of the petitioner was found to be L1, the same was cancelled, whereafter another process was initiated, wide at notice dated 21/10/22. The case of the petitioner is that in the second process, the bid submitted by the petitioner has emerged as L1. However, there is a note by the authority recommending rejection of the bid of the petitioner on the ground that supplies of the sample were of inferior quality. This was noted, madam. My was clear, his was said to be inferior. It's there in their submission itself. The learned counsel for the petitioner submits that apart from the fact that the very less time was granted for making supplies of the sample, the recommendation is not based on this, is not on the basis of quality, but certain lack of fitting which could not be done because of constraint of time. On the other hand, so and so, learned counsel for the respondent number 5 submits that, so my lord will ignore that and the next paragraph. Then the next, the court is of the opinion that the petitioner be afforded with another opportunity to place the sample of supplies which he proposes to make within a period of 10 days from today, and there will be a fresh inspection assessment of the supply. My lord will know there will be a fresh inspection and assessment of the supply made, and a decision would be taken. It is needless to say that such decision be taken independently and fairly, and the outcome may be informed to this court by the next date fixed. In view of the above, the petitioners make the supply of sample within the period stipulated above, and decision to be taken thereof within a period of 2 weeks thereafter. The matter be listed for consideration on 3/5/23. Where is the liberty given here, my lord, to effect the supplies or pass a work order? This honorable court said, you go ahead, make that assessment, come back to us. Because there is already a restraint order from my lord, which says without the response number 5, in that case, disclosing the reasons, the work order should not be issued. Now, this honorable court says, okay, we give you an opportunity. You said there was lack of time. We give you an opportunity. Let there be an inspection and assessment, and thereafter come back to me. And my lord will see the matter be listed for consideration on 3/5/23. Where is the, my lord, order which permitted the respondent authorities to go ahead and give it? There was nothing. Now, my lord would see why this is happening, my lord. If my lord comes to the writ petition of the 8353, my lord. Now, by coming before this honorable court, without making me a party, not disclosing the total details, my lord, he has tried to improve his position, my lord. Which I would even not use the word mislead, but my lord, it tantamounts to that, my lord. Now, my lord would have the affidavit that was filed in 8353/22 by the college school authorities, my lord. It's filed by one Mr. Makhan Bora. He is the principal. My lord would have page 5, second paragraph.
Just a moment. Yes, what you are referring to?
My lord, I'm referring to the affidavit filed in 8353 by respond number 5, my lord. The tendering authority. my lord.
Yes,
My lord, we'll have page 5 there, my lord.
page.
5. The second
Yes.
paragraph. Page 5, second. On 19/12/22, samples of furniture supplied by both the bidder was inspected by the approved inspection committee, and a report was prepared and submitted before the additional deputy commissioner for further direction on 20/12/22. On 23/12/22, the additional deputy commissioner put up a note in the concerned file tender dated so and so, stating that after inspection of the samples of furniture, a comparative statement of samples was prepared, and the samples presented by L2, that is me, my lord, is found to be of superior quality, and therefore work order may be considered for MJ Enterprises, that is L2. So, my lord, here, this, my lord, give me a right. So there was a decision. Final, it did not reach, but the processing was there. Now, when you approach this honorable court, these aspects which you knew, I was there also, my samples were considered. You signed on that paper. Maybe these decisions came subsequently, but on 19th, you knew about it. You make wild allegations in the repetition that it is for some favored boy, some X, some Y, Z. What prevented you from making me a party, man? It would not have boiled down to what we are facing today, my lord. Now, my lord would see the next statement at page 7, para 12, second paragraph. The deponent further submits that the
just
samples
now,
provided by the petitioner are not of good quality and not as per specification. It is pertinent to mention here that the petitioner was also a participant in a tender of supply of furniture in Adarsha Vidyalaya Tatari, Bongaigaon. This is a different one, madam. And in the said tender also, samples were called for from the bidder, and in the said tender process, the petitioner samples were not found to be of good quality. In fact, the petitioner participated in tender process of various districts for furniture supply in Adarsha Vidyalaya, and in every tender process, the quality of samples and furniture are not as per specification and guideline. My lord, I am not privy to the reply, if any, filed to this, my lord. My lord would have page, the annexure to that, which would be, my lord, annexure page would be 10, my lord.
No, that is not a matter in issue.
So that I'm showing, my lord, why? He says, my lord, samples should not be called for. My lord will only have page 10, my lord. This is a different
I've seen that.
Bongaigaon. Here, my lord will see MJ and JMK. So, my lord, sample collecting is common to all, my lord, in terms of the new clause that was inserted. So, if the samples were called for, and my lord, an examination was made and a decision was taken, then, my lord, without, my lord, interfering with that decision-making process, which was never highlighted before your lordship, only an indication was made that there was a note. This honorable court said, okay, fine. Allow him to supply the samples once again. Now what has happened, my lord? There is no inter se comparison of the quality. The assessment is not there, my lord. The assessment which was there in the first round is not there. The petitioner got 3 days time, at least. I was asked to do it overnight, my lord. Whether that would be permissible. Now, my lord would come to the writ petition, my lord. 8353. Para 14 at page 11, my lord. Page 14, para 14, page 11.
Well, I'm here to show you something. Today during tiffin time, I have been checking up samples.
Oh, that's the normal practice, my lord.
Samples, these are kits to be given for a meeting which is being held on Sunday, is a Saturday. And
Samples are-
afternoon lunchtime was spent in looking at the samples.
That's a normal, because my lord, you get the whole lot, it's bad. It's better you have a sample, my lord. Now, my lord, will come to page 11. I am on the part, my lord, that they have, why they did not, my lord, implead me as a party respondent, which, my lord, for the non-impleadment, the repetition itself is not maintained. My lord, will have para 14, page 11. Of WPC 8353.
Repetition,
Writ petition.
para 11,
Para, page 11, para 14.
yes.
That finally petitioner has received one notice through WhatsApp dated 14/12/22, whereby the present petitioner as well as another firm, namely MJ Enterprises Guwahati, have been directed to provide sample of school furniture of all items as per specification on or before 19 December 22. The said WhatsApp message was received by the petitioner on so and so, and there were only 2 working days, 16th and 17th, 18th being Sunday. Petitioner had submitted the sample hurriedly on 19/12/22. Now, my lord, will see para 15, what his case is, my lord. That the petitioner has submitted some sample with a representation dated 19/12/22, stating that the authority has asked for sample for 2 firms, that is L1 and L2, though without rejecting the tender, asking the sample of L2 does not arise. If petitioner's furniture are found to be defective or not within the specification, and after rejecting the petitioner's sample furniture, they can ask for L2 or L3. Petitioner further alleged that asking for sample from L2, L3 clearly reflects there is a deliberate intention of the authorities to allow the work to other participants, and it is further stated that within a short period of 3 days, it is not possible to submit sample of furniture. So, my lord, that pleading was there, but that was not challenged. Because in every other Vishwavidyalaya, at least one example from the respondent's affidavit, I could show that this is the normal procedure done. L1, L2, if the L1 satisfies the samples are as per specification and good quality, there is no question of taking it from L2. That's the norm. We are businessmen. We are doing this supply everywhere. We know it. Now, my lord would see. We compete. We are competitors. Man. Now, having said so, my lord, my lord will come to page 13, para 18. Whether after this, there is any requirement, my lord, to continue with the matter. My lord will have to interfere with it. Page 18. I'm, my lord, submitting to this, my lord. That petitioner further begs to state. Page 13, para 18. Petitioner further begs to state and submit that the notice inviting tender was neither published in local media, in local newspaper, nor circulated in the social media. It was confined only to the notice board of the school, only to issue work order in favor of the selected person. As per decision of the Deputy Commissioner Dorong, the petitioner also came to know from the reliable source that already a decision has been taken to allot the work order in favor of person under control and choice of Deputy Commissioner Dorong. As a result, earlier tender process has been cancelled and invited fresh tender, but the petitioner again became L1. Therefore, also they did not want to allot the work in favor of petitioner by hook or crook. It is clear case of abuse of power and authority by the Deputy Commissioner Dorong. Now, my lord, after the minutes came before your lordship, when it was there, the only plea now taken is, my goods were not bad. Some fitting problems were there. My lord, when a supplier is supplying goods, he must give the good as it is. Now, the bag has come to your lordship. I don't give the chain. the hook there. Whether my lord will accept it, I'll give it. I did not have time, I have not given it. My lord will have to have the whole product, which my lord will use.
Unless you buy it from Amazon.
Amazon. Amazon has a replacement policy.
No, but then you'll have to fit it yourself.
But here when you have given it, so my lord, my submission would be, my lord, that the very repetition of the first one, 8353, is not maintainable. Because that, although allegations were made, I was never made a party respondent. This honorable court, if had given me an opportunity by issuing a notice to me in that case, I would have come and contested, my lord. Because a decision was already there in my favor, which was also brought on record in the proceedings, and that was never challenged. Two, my lord. This honorable court, in my absence, in 31-5-23, my lord Justice Mary's order, because that fact that I was also there, my goods were also seen, was not there. This honorable court, my lord said, okay, fine. You got 2 days time, you take 10 days time. You supply afresh. Then the authorities on inspection and assessment, my lord, both the words are there. My lord will check from the records whether there was an inter se assessment made as in the first instance. Then this honorable court said, come back to us with the decision. But the respondents, my lord, overstepped that order and issued work order to the private respondent here and the petitioner in 8353, which was never intended by this honorable court. What was the rush? I don't understand, my lord. Because this honorable court directed that it wanted to satisfy itself because there were material before this honorable court which indicated that the samples were not good, not only here, in other areas also. So this honorable court wanted to satisfy. That's what is being flowing from that order. And thereafter, if the court is satisfied, you can go ahead. Then I filed when I get to know, my lord, that this work order is being issued, I come up before this honorable court. I was not aware, my lord. Before the date of moving, my junior instructed me that there is a writ petition filed, and it is because of that this order came to be passed. Then we got, my lord, on that day, unfortunately, even that order was not with me. It was thereafter I got it, my lord. It was just in the morning hours I got it. The net was not working. Then I told, this was informed to the honorable court. Mr. Goswami was also there. The honorable court said, okay, fine, let us have it on 3rd. Then I told the court that, my lord, because of this order, supplies will be made, my case might become infructuous. Then this honorable court added that last line, that anything done would be subject to orders that would be passed in 3-5, nothing happened. Then, my lord, in spite of that, fine, they supplied some items which was brought to my lord's notice, but the majority items were not. 81 pieces were supplied. Around 300 something was there. The rest was not supplied. This honorable court, then after hearing all, my lord, said, fine, we will thrash out this matter. Till that time, don't make the supplies. And my friend was directed to produce the records. What I highlighted was, in the second round, whether there was an inter se comparison with regard to quality. Specification is one thing which was also looked into, and the quality was also looked into. So what have you done? If you have done both, fine. If you have not done it, my lord, then, my lord, the petitioner cannot insist that being the L1, he should be given, because this is in larger public interest, my lord. He gives bad goods, then again that will be replaced. Whether what is the guarantee, my lord, that goods will also be good. So this process will go on and go on. That is why the samples were called for, my lord. So that the school will suffer otherwise. So in this fact situation, my lord, the allegation of suppression will not lie, my lord, because it's the other way around. Because of your non-impleading me, my lord, this has led to this. So in that view of the matter, my lord, and his prayer also, if the whole tender process is set aside, I have nothing to say, my lord. I have nothing to say. I have nothing to say. Their prayer, my lord, in para 18, if it is accepted, I am also there, my lord. Let there be a fresh consideration. But, my lord, in this manner, once there is already an opportunity given, the second thing that has been given is solely to him, not to me. This is my humble submission.
My lord, I'll just take.
Just a moment, Mr. Bhattakur has to say something.
Oh, sorry.
Lordship, I am not squeezed person.
He was in a rush. That's the problem.
Here, not in a rush, your lordship, but we have, your lordship, the urgency, your lordship. And we have in your lordship on several occasions in the first round of litigations that the writ petition represented by my learned senior counsel, your lordship. We have made that we are in need of these materials, your lordship. We are not concerned with the materials only, your lordship. We are not concerned with who gets it, your lordship. We are concerned with the materials, good quality materials and early delivery of materials. These are the three requirements for us, your lordship. Now, your lordship, so far as your lordship, I am concerned, I will only, your lordship, submit from the record, your lordship, nothing more than that, your lordship. Since there is an order passed by a coordinate bench, your lordship, we have not objected to that. We have not filed any appeal against that, your lordship. We will have to abide by that, your lordship, and therefore we will not make any comment on that order, your lordship. Now, your lordship, this is a fact, your lordship, the rate, so far as the rate is concerned, he quoted a rate of 27,88,270. And the respondent, your lordship, the counsel, the petitioner in the other writ petition, your lordship, the second one, your lordship, he quoted, your lordship, 29,89,240, your lordship. Now, your lordship, on the day when the first sample was called for, your lordship, for the first time sample was called for, your lordship,
Just
on 19th
rates of L1.
lordship,
What are the rates of L1?
L1 quoted a rate, your lordship, 27,88,270.
Yes.
And the L2 quoted, your lordship, 29,89,240. That is at, your lordship, flag F of the record, your lordship. Now, your lordship, when samples were called for, your lordship, that is at flag I, your lordship, it was inspected, your lordship, and your lordship, the writ petitioner, your lordship, L1 bidder, your lordship, he could not submit, your lordship, sample in respect of 1, 2, 3, 4, 5, 6, 7, 8 items, your lordship.
Yes.
And your lordship, 2 of the items, your lordship, at serial number 10 and serial number 12 were not as per specification, your lordship. After that specification, your lordship, the ADC, your lordship, put up a note, your lordship, and that note, your lordship, is at flag Y, your lordship, that is dated 23/12/2022. And this note reflects, your lordship, as such, the physical verification of report of samples as put up in flag I. The samples presented by MJ Enterprise is found to be superior quality. We may therefore consider work order for MJ Enterprise. But, your lordship, no formal decision has. It was a note up by the ADC, your lordship, and at that point of time, your lordship, this writ petition is filed, your lordship. When this writ petition is filed, your lordship, and we filed our affidavit, your lordship, our specific case was that, your lordship, the supply of sample was as reflected from the record, your lordship, that this the samples were submitted, but the inspecting authority found that the samples were not as per, your lordship, specification. Then, your lordship, this honorable court passed an order, and after that, your lordship, fresh samples were submitted, your lordship. That will be at flag N of the record, your lordship. And this time, your lordship, the inspecting authority found they have supplied all the items, your lordship, new samples, your lordship, and all these items were as per specific. Now, so far as both the, your lordship, L1 and L2, we got it, your lordship, as per specification. Since your lordship, specification is the only issue, your lordship, we have noted specific. And we have not made any other, your record does not reveal, your lordship, any quality assessment is made or not, your lordship. This only says, your lordship, findings as per specification, as per specification, as per specification. Now thereafter, since we are, your lordship, we are in need of these desk and benches, your lordship, and we have been using, your lordship, using this, taking it from, your lordship, some other schools, your lordship, on loan, your lordship. Therefore, having found this, that these are as per specification, we issued the work order, your lordship, and as per the work order, he submitted some of the materials, your lordship, but your lordship, on the given date, your lordship, on 3/5, your lordship, when I was supposed to inform this honorable court about the consequences of the fresh inspection, your lordship, on that day, both the cases came up, your lordship, most of the decisions were placed before this honorable court, and the honorable court put a specific query to me as to whether all the goods were supplied or not. And that, your lordship, on that date, your lordship, the desk and benches were not supplied as per verbal instruction I have received, your lordship. I have submitted that, your lordship, and that basis that order has been passed, your lordship. And today, your lordship, my instruction is that, your lordship, desk and bench, table for principal, table chair for library, and table chair for laboratory. These are the components, your lordship, that has not been supplied, probably, your lordship, due to the order passed by this honorable court, your lordship. But this has not yet been supplied, your lordship. Rest of the materials, your lordship, they have supplied desk bench, 100 desk and bench. Now, this is, your lordship, and rest, your lordship, I leave it to this honorable court, your lordship. These are the record, your lordship, and this is what I get from you.
What are yet to be supplied?
Yet to be supplied, your lordship, 100 desk and benches, your lordship, table chair for principal, table chair for library, table and chair for laboratory.
Some items are lost.
Only one submission from that records which they have subsequent inspection as per specification. My lord, these are furnitures, there will be a specification for that. Specification would be length, breadth, and all those things, my lord. The quality admittedly has not been an assessment.
My lord, my learned
Matter
friends,
is there. Annexes.
my learned friend is talking about quality, my lord. My lord will kindly come to page number 24 of the other, his repetition. My lord, pursuant to the first tender, why his tender was cancelled? Kindly see, my lord. He is talking of quality. Page 24. Because this goes to the root of the matter. Kindly see, my lord. JMK Enterprise, that is the petitioner. Yes, all correct. Kindly see, my lord, 2. MJ Enterprise, that is the petitioner. Brand is not approved by the PWD by letter dated so and so. But what is the brand? Godrej, Wipro, Johari, etc., etc. Now, he is not a dealer of any branded item, my lord. That is why in the second tender, this requirement of brand is done away with. That is why the ADC says, my lord. This quality, who is ADC to say, give a comment that the quality is inferior, my lord? Is he an expert? I can know, my lord, when it comes to measuring land, because of the survey training they take, they can say, all right, this much of land. But who are you to say that it is inferior quality? You never insisted on any quality in the tender. So therefore, my lord, let's not go to all this quality aspect. This was the position pursuant to the first tender. Now, my lord, my learned friend referred to certain averments in the affidavit filed by the respondent number 5. That was pursuant to the first exercise.
Nowadays, any brand you take, it has a what you call
Brand name.
a lifespan. 2 days after the lifespan, it goes bad. The warranty period, you buy a press. Immediately 2 days after the,
It will stop working.
it starts working.
My lord, my learned friend referred to the affidavit of the respondent number 5 to rely upon certain environments. My lord, those were pursuant to the first exercise which was taken. Those are not post, my lord, 31/3/23 order. So, my lord, certain shortcomings were there in the samples which we supplied, my lord, pursuant to the first exercise that we are admitting. We ourselves said because of paucity of time, we could not get the time. Then, my lord, my learned friend also referred to page number 34 and 35 of the writ petition to show the shortcomings in the samples we supplied. Those were, yes, those were pursuant to the first exercise. We admit, my lord. Nobody is disputing those. Now, my lord, will kindly come to the this, my lord, the comparative statement prepared at page number 28, my lord. Now, kindly see, my lord. For example, Dorong Furniture, this is the first party. He quoted a rate of 29,49,132. Just to show, my lord, that there was an application of mine by the authority. Then, my lord, kindly see remark, certificate and authorized sale dealer of Tata Steel. But his rate is high, my lord. Then kindly come to Kushi Enterprise, sub-dealer of so-and-so, 38 lakhs and odd. Now he is the, my lord, petitioner, MJ Enterprise, 29,089. Yes, sir. 29 lakhs, 89,000 and odd. And you see, my lord, he is not any dealer of any party, my lord, any recognized party. Now please come to the last one, SS Enterprise, retail sub-dealer of authorized SS Tata Steel. So he is not authorized dealer or retailer of any, authorized company, my lord. Then please come to, my lord, page 30. Party talking of, my lord, quality, he doesn't belong to anything, my lord. He'll just buy something from market and supply. And he wants to talk about quality. And listen, my lord, Kalyani Traders, he have quoted 22 lakhs, no dealership certificate. Similarly, my lord, Khaitan Carpet Corporation, rates not quoted. Then, my lord, Messrs. Harsita, so-and-so, sub-dealer of authorized dealership. Yes. So therefore, my lord, to speak about, my lord, quality is, my lord, hardly matters any consideration. Now, my lord will kindly come to page number 22. My lord, we are not dealing with any rocket science, my lord. We are dealing with supply of school furniture. Kindly come to, my lord, page 22, the guidelines. What are the procedure which is to be followed? Serial 4, steps to be followed for procurement of furniture are as under. This is the guideline, my lord, under which they are to follow. Please come to D, my lord. Purchase order will be issued to the lowest bidder if qualified as per terms and conditions in quotation call letter. E, on delivery of furniture at school, the same shall be inspected, and if any item found to be inferior to the specification or defective will be rejected. Such item when replaced should also conform to the said laid down specification. On successful and satisfactory delivery installation of furniture, the received voucher will be signed on behalf of the SDMC by member secretary on approval of the SDMC. My lord, there are enough procedural safeguards. My lord, yeah, even if the sample is approved, even thereafter, my lord, there will be inspection. If there is any shortcomings, then, my lord, they are bound to replace it. It is only thereafter, my lord, even the replaced thing has also to conform to the specification. Then only, my lord, the voucher will be signed by the competent authority. Now, my lord, where is the wrong in this case? It's a procurement of school furniture by that too by the, my lord, school management committee. And this is because of the circular, my lord, depending on the value. Only when it exceeds certain value, my lord, then only one reason is required to resort to competitive bidding. Then my lord will kindly come to next page, page 23, serial number 5. All activities of issue of quotation, supply order to lowest bidder, receipt and accounting of furniture and release of payment shall be approved by resolution of SDMC, and all documents records shall be maintained separately for inspection by any representative officer team submitted by the State Mission Office, RMSA. So these are the guidelines under which, my lord, the procurement is to be. Now, my lord, pursuant to that order dated 31/3/23, when an opportunity was given to the petitioner, my lord, there is no dispute that the petitioner is L1. There is also no dispute that my learned friend's client is the L2. There's a difference of almost about 4 lakhs. I have quoted about 25 lakh 11,000 and he quoted 29 lakhs 89,000, more than 5 lakhs. So, my lord, therefore, an opportunity, only because I was L1, my lord, and having regard to the scope, that there is a scope for reassessment even after approval of the sample also. At the time of delivery also, they can insist on that. So let, my lord, the authority insist on me supplying as per the specification. But where is the wrong? What is his enforceable right? Now, as a L2, what is your right? Now, my lord, therefore, if you are so aggrieved, even after coming to know about this, even after 3/5, you could have filed an appeal before the division bench. You could have filed for review of that order dated 31. You never did so. Is it not too late in the day, my lord? So that order has attained finality, and according to that order, subsequent actions have been taken. And as pointed out by Mr. Bhattakur, my lord, my learned friend, my lord, the samples were conforming to the specification. End of the day, my lord, I have partially made supplies also. Some of the items are left. Therefore, in my humble submission, I don't think there's anything left in this case, my lord. And my lord, as per the CVC guideline also, my lord, which we have annexed in our affidavit, so lordships will kindly have that for a moment. Affidavit at page number 49 and 50, my lord.
Of which rate petition?
Of 2189, my lord. Page 49. On top, please refer to CVC instruction issued under letter dated 18/11/98, banning post-tender negotiation except with L1, that is the lowest tenderer. And I have referred to that, my lord, procurement guideline, which also speaks of lowest tenderer, my lord, which are, my lord, complementary of each other. These are consistent. And then if my lords could come to page 50, my lord. Circular. And so attention is invited to Commission Circular dated 3rd of March 2007 on the issue of tendering process, negotiation with L1. It is clarified to all concerned that there should normally be no post-tender negotiation. If at all negotiation are warranted under exceptional circumstances, then it can be with L1 only. So, my lord, the law is also well settled in view of the CVC guidelines. At all there is any requirement of the negotiation on anything, my lord, then it could be only with the L1. And my lord, having regard to the nature of the supply and on the provisions contained in the procurement guideline, I don't think, my lord, any failure of justice has occasioned in this case to invite your lordship's intervention by way of a writ of certiorari. It's a plain and simple bona fide exercise of power. Yes, they were right, my lord. Initially, they found that our samples were, there were some shortcomings in the sample which we, provided. Subsequently, in pursuant to the, order given by this honorable court, my lord, the action has been taken. My lord, herein I will refer to one very important principle, my lord. A court's order cannot prejudice anybody. Order dated 31/3/23. The other side cannot have any grievance because a court's order cannot prejudice anybody. I forgot that principle, my lord.
It is, I have it,
Ah.
I use it.
Yes,
Actus,
that principle
actus
is, my
reus,
lord.
actus reus,
It is. Dhananjay Malikore case too. My lord, that principle is laid down in this case, my lord. I think 2008, no, Dhananjay Malik. 1988 2S, no. Actus cure nememim.
actus curiae, gravit, yeah, gravibit.
Actus cure nememim
Gravibit.
grevevit. 2010 4 SCC 437. Actus cure nememim grevevit. Court's order cannot prejudice anybody. And the citation is 2010 4 SCC 437. So therefore, my lord, the comprehension of the petitioner in other the 2189 of 23, in my humble submission, is wholly misconceived. Apart from that, my lord, he does not have the other party do not have any enforceable right as an L2. Even if, my lord, he had an opportunity, he had missed the bus, he could have challenged it, he could have filed a review, he could have filed an appeal. Nothing has been done. He could have sought impleadment in the case, and my lord sought recall of that order. Nothing has been done. That order has attained finally. And my lord, since, my lord, it is something which concerns the interest of the students, so my lord will vacate that interim order and dismiss the writ petition, that is 2189 of 2023, and allow the writ petition filed by us, my lord. And our furnitures are ready, my lord. Anytime we can supply whatever was remaining. Actus. That is my humble submission.
But Mr. Ken Chaudhary, senior counsel, assisted by Mr. S.K. Goswami and counsel for the petitioner in WBC 8353 of 2022. Mr. UK Ireland, senior counsel, assisted by Mr. B. Kaushik Leonard, counsel for petitioner in WBC 2189 of 2023. And Mr. S. Bhattakur Leonard, counsel for the Adarsh Vidyalaya, Belgaum. Who has also produced the records. Perusal of the record would take some time based on Monday for delivery of orders. 19/6/2023 for delivery of orders. The eviction matter,
530 same DAG number.
530, same.
Regarding submission of return. Yesterday's case process fixed.
P. Bora, counsel for the petitioner. Eviction, 530. Last week gave time till when?
Yesterday, my lord, two matters came up before this honorable court. The High Lordship has granted time till 16th. This can also be. Tomorrow is 14,
Tomorrow is 14. 16, same day.
same day 16th. My lord, only
16.
one submission, if my lord can, or my lord add to my lord's order. Lordship has directed the Deputy Commissioner, my lord, I'm just reading that particular portion, my lord, on such an application being filed, the Deputy Commissioner Kamrup Metro Guwahati shall sympathetically consider the said representation in the light of the prayer made to grant reasonable time to make alternative arrangement, and if deemed appropriate, to grant some reasonable time to the petitioners to remain in the house under their position. Here, Lordship may kindly add, my lord, that the Deputy Commissioner Kamrup Metro in consultation with GMDA, because what I have been instructed today morning, my lord, that this exercise is carried on by GMDA. Now, the district administration is only, my lord, providing the magistrates. The entire exercise has been planned by GMDA. So if only the Deputy Commissioner is directed, my lord, he may face, my lord, he has to take the GMDA into the loop. So that is what I have been instructed. In consultation with the GMDA authorities, that much will suffice.
Deputy Commissioner to take a decision in consultation with GMDA.
Yes, Deputy Commissioner in consultation with the concerned GMDA authorities, only that much, my lord.
Okay.
Yes, he will do it, my.
Same order, yesterday. Yesterday item, it was WBC.
Publication of. I'll perfect.
Give it to the court master. Same. Mr. Arbor Pujari for revenue. For government will be there. So who was there?
Should
Mr.
be
S.
about the
S.
name
Bara.
of Sumitra Sharma. I will
Okay,
convey.
okay. No, she was here also.
Yes.
Mr. S. Bara for GMC and GMDA.
And only GMD is there.
Achha, only GMDA. Okay, only GMDA. And Ms. S. Sharma, government advocate, appearing for. She will be for respondent number. Government will be for.
My lord, I am appearing for R1, my lord.
Or she will be for 3 and 4. Government advocate for 3 and 4. GMDA number 2. Same order. 20, next date is 28/6.
28/6 is the date, my lord. I'm so obliged.
But have they taken an in principle decision?
Yes, my lord, I have already conveyed my lord's order in my lord that 5 writ petitions, my lord, coming before
No,
my lord
I was-
last Friday.
I'm just wanting that they should take a decision and then
Yes, yes.
instead of people coming to court,
Yes.
they should take a decision and they can themselves regulate.
No, that also I have, my lord, conveyed. I'm just awaiting the instruction, my lord.
Okay.
But perhaps, my lord, by 20th of this month, on the next date of listing, I should be, my lord, having some instruction to that extent, my lord. I have already conveyed, my lord. Thing is that, my lord, the district administration in consultation with GMDA, my lord, they will have to sort it out. Publish.
7 to 14 stay methods. Well, so far item number 7 is concerned, I mean, item number 7 and 9. The subject matter will be similar, but they are different. Although tagged together, 7 and 9. I do not know about the others. So far as item number 7 is concerned, it is basically that under section 130 capital A of the Assam Cooperative Societies Act 2007, the amendment, a notification was issued on 27th of January 2022, whereby exemption was granted to certain societies for the period 1/10/2020 up to 29/3/2021. That is there at page 19. Lordship has seen that. What we are on basically, page 19, my lord. May I read that part, my lord?
But why should you extend the stay after that? That extension you have enjoyed for a particular time.
We are on a different footing, my lord. We are submitting that this order is notification neither here nor there. The reason is, it says the exemption under 130A has been granted from 1/10/2020 to 29/3/2021. Now, this is issued in January 22. So we cannot go back to the past and hold the meeting and come back again. The entire idea of section 130A was to save us from the wrath of section 39. Section 39, my lordships, if lordship takes for a moment section 39 of the act, this refers to a different time period. 39 of the act, my lord.
In fact, in my book, I don't have that 130 capital A also.
Lordship, I may hand over this. But no, so 130, yes.
Yes, sir, good day. Yes, sir.
Section 39, if lordship may kindly take for a moment. May I read, my lord?
Election,
AGM 39.
oh, 39,
Yeah.
AGM, yes.
A general meeting to be termed as annual general assembly of a registered cooperative society shall be held at least once in every cooperative year within a period of 6 months of close of financial year to transact the business as in the act. The board shall automatically stand dissolved for not holding the AGM in accordance with the provisions of this act and bylaws within 6 months from the expiry of every financial year. In substance, March, the financial year closes, April to September 30th, 1st April to September 30th, the requirement of section 39 has to be complied with, else automatic dissolution follows. Now, when the pandemic hit, Miller, people were not even allowed to hold the meetings. It is at that time, the legislature, Miller, there was an amendment and 130 capital A came. If I may read 130 capital A for a moment, Miller.
It is the power of the government to extend.
Power of the government to extend is there. The purpose of extension is that I have to hold a meeting to regularize section 39. Government exercises power under 130A. May I read? The state government, in exceptional circumstances like pandemic, may by general or special order exempt any registered cooperative society or class of registered cooperative societies from the operation of the provisions of section 39 and section 41(2) of this act for such a period not exceeding 6 months at a time, which shall not further be extended for more than another 6 months, as may be specified in the said order, or may direct that such provisions shall apply to such society with such modifications, and for such a period, either from a prospective or retrospective date, as may be specified in the order as per the need of the situation.
You see, Mr. Panik, what we can do is that since you are enjoying this interim order for some time,
My lordship.
we can only say that within a period of 45 days or 60 days, you
Very-
hold a
very-
AGM.
That's all I wanted, because this notification puts me back in time. It does not give the financial year benefit.
No, this I have, you see, I have read this. You see, it gives only power to extend it for 6 months.
No.
Or second
The
extension
purpose of
for,
6 months is something else. 39, as I can see it, my lord, 39 is 1st of April to 30th of September. I have to hold the meeting. If I do not, automatic dissolution follows. Since pandemic came and people, societies could not hold that meeting.
it's okay, but the
So they
extension is
gave the
for 6
exemption,
months.
but here the exemption was in the past
Has to be, because you see, it is 6 months only.
with a rider should have been that you hold it in the future within 2 months, which your lordship is granting now. That's what we wanted.
You hold it within
That's all.
a limited time.
That's
My lord, here, in fact, the not holding of the election or AGM, Lordship is aware twofold consequences. One, dissolution. Board dissolves, gets dissolved. And the other part is, my lord, the disqualification. Now your Lordship will exempt the disqualification part. Now there are some boards, my lord, here, my lord, who are running, my lord, in 7 years. 7 years. So beyond, my lord, the 5 years. So in those cases, my lord, in fact, my lord, in view of section 31 and 41(2), they are not empowered to hold the election. Departmental officer will
We
hold.
will take it one by one.
Yes.
In this petitioner's case, what is the, how much time he has crossed?
He's expired on May 2023, already expired.
May 23.
May
the 5 petitioners before your lordship.
May 23. So Lordship will say, my lord, the departmental officer will hold election within 45 days. They will participate, board of members.
So far as the expiry part may not, that I may not be aware of that presently, because there are 5 writ petitioner societies.
No, that, my lord, that is their case.
No, but before that, he has got a stay. It is a no coercive action. Oh, it's not a coercive action, it's an operation of law.
Operation of law, no coercive action, my lord.
Okay,
Operation of law.
okay.
Page number 7 for a moment, writ petition, the time period is given.
Yes, that is there, that is there.
No, that's why I asked. So that operation of law can't be postponed by the court.
Yes, my lord.
No,
So therefore, it will be the authorities and you will be participating in the election.
Participate.
Correct. Good. Mr. S. Banik, this is item number,
7, my lord.
no, 7 and one matter, 9.
so far as page number 7 is concerned, item number 7, page 7, my lord may have a look. All the petitioners may not be similarly positioned as of.
No, I'm just asking you. That's why I'm asking you. I'm taking up one matter
No,
at
no,
a
item
time.
number 7 only I'm referring to. Page 7.
Yes.
Paragraph 3. So far as number 1 is concerned, first AGM was 18, so 23 would be over, 5 years. Second one is 18, 23 would be over. So far as third one is concerned, 20, that would be still be alive. So my friend may not be correct, may not there. The fourth one, 19, would still be there.
No,
And
no,
the fifth one
election
would
was
still be
held
there.
in 18, my lord. Election was held in 18. Election AGM.
The first
election
AGM is there,
Election
it's for
was
5
held-
years.
Election was
In
held in
between
18.
COVID came.
Election was held in May 18. So therefore, May 23, my lord.
No, I am not on the first and second. I am on the third, fourth, fifth.
He says there are many petitioners here,
There are 5 writ petitioners,
5 petitioners. Page 7,
page 7.
he has given a chart.
For the rest 3, lordship will fix, give some time, 45 days, whatever date, we'll hold the election. within the voter list has to be there, the publication has to be there. So that time period may be granted. Strictly, it have to go. So that's what we wanted. 1 and 2 would go. Department.
It's a 5-year term.
Five-year.
So 5-year term is not expired according to you.
Yes, for the rest 3.
No, but this they can't be correct. You see, last AGM not held due to COVID.
My lord.
So if AGM is not held, you become a defaulter.
Because we are saved by page 19. We are saved by page 19. Page 19 gives us an exemption, but does not give us a time to hold the election.
No. AGM is after how many years?
For
There is an
either
AGM.
concern,
Every year there is an AGM.
AGM,
Every 5 years there is an election.
election. So far as 3, 4,
Okay, so
5 is to-
AGM for this. Okay, I now get it. 3, 4, and 5 for
3, 4, and
AGM. We give you some time.
Yes.
Okay. But Mr. S. Baniklan, counsel for the petitioners, and Mr. S. Talukdar, standing counsel for the SK Talukdar, standing counsel for the Cooperation Department, representing respondent numbers 1, 2, 4, 5, and 6. And Mr. C.K.S. Barwal, and the government advocate appearing for respondent number 3. In brief, the case of the petitioners is that to is that a new section 130 capital A was inserted in the Assam Cooperative Societies Act, 2007, which gave power to the state government power to exempt any registered cooperative society from the operation of the provision of section 39 and 41 within bracket 2 of the Act for a period not exceeding 6 months under exceptional circumstances like pandemic. First of all, the competent authority in excess of power conferred under section 130 capital A of the 2007 Act, Assam Cooperative Societies Act, 2007, within bracket 2007 Act in short, issued a notification dated 27/1/2022 thereby granting exemption for a period from 1/10/2020 to 29/3/2021 to the societies as mentioned, to the societies whose name are mentioned in the said notification. Full stop. The case of the petitioners is that by the time the notification was issued, the period of exemption had already elapsed, for which the benefit could not be given to the petitioners, and that by operation of the provisions of section 39 of the 2007 Act, the petitioner had already, there was a lapse on part of the petition, so all the election, that was all the AGM within the time allowable under section 39. And that the provisions of and that the petitioner also did not get the benefit of section 41 within bracket 2 as during the said period, the elections of board of directors of the societies could not be held. Full stop. In short, comma, the benefit of the notification dated 27/1/2022 could not be availed by the petitioners. Full stop. Hence, comma, the learned counsel for the petitioners has submitted that insofar as the petitioner numbers 1 and 2 and 3 is concerned, 1 and 2 is concerned, comma, they may be given as the board had lapsed after expiry of 5-year term, comma, the same shall not be construed as a disability to the petitioner, to the members of the board of directors of the petitioner number 1 and 2 society to participate in the elections. And so it is also submitted that in respect of petition numbers 3, 4, and 5 are concerned, comma, adequate time be granted to the board of directors to hold the AGM as the term of the board has not yet lapsed. Correct?
Yes.
Next paragraph. The learned standing counsel for the cooperation department has submitted that by operation of the provisions of section
31, my lord, and 41-2.
31,
5 years from the date of election, that is 31.
by operation of 31, comma, as the term of the board is prescribed to be 5 cooperative year from the date of election of the directors, comma, for those societies where the election could not be held, comma, the board is already deemed to have lapsed
Right.
by efflux of time. And therefore, while it would be the discretion of the court to make the directors eligible for re-election, comma, such elections are to be conducted
Departmental.
by
officer under
the
41-6.
department, by departmental officer
Under
under
41-6.
section, under
41 subsection 6, madam.
6,
Subsection 6, 41
okay.
subsection 6,
under clause 6 of section
41.
41. Under subsection 6 of section 41 of the 2007 Act. And what about the AGM?
AGM, my lord, in fact, other boards will hold the AGM 3, 4, and 5.
Okay.
And
And insofar as the petitioner number 3, 4, and 5 are concerned, comma, it is submitted that it would be the discretion of the court to extend time to the said societies for holding the AGM.
they will, my lord, continue my lord, until expiry of their 5 years from the date of their earlier election. Lordship will make it clear, 3, 4 and 5.
As their 5 cooperative years would commence from
From the early date of earlier election.
the date of earlier election. Whenever the same were held.
My lord,
Next paragraph. In view of the discussions above, the court, on considering the fact that where is that notification?
19.
In view of the contents of the
Only thing our disqualification may not come in so far as one is.
notification dated 27/1/2022, issued by the Additional Chief Secretary to the Government of Assam Corporation Department. The court is inclined to observe that the intention of the government was to exempt the societies named in the said notification. Extension of the exemption to the said societies from operation of section 39 and 41(2) of the 2007 Act. However, by the time the notifications were issued, the time the extension granted had already expired. The exemptions granted had already expired. Under such circumstances, the court is inclined to provide that the non-holding of AGM and of the elections by the petitioner number 1 and 2 societies, namely so and so, shall not stand in the way of disqualifying the present board of directors to participate in the next elections. However, it is provided that the elections would be held by the Assam by the authorities
under section 41(6).
authorities assigned by the registrar of cooperative
Registrar of
societies to hold such election, which will be done departmentally.
Right.
Within an auto period of
Within a period of 45 days from today, my lord,
within a period of 45 days from today.
because some
We have
notice
to
is
do
also
35
required.
copies.
Huh?
It will take a couple of days time.
Okay, within a period of 50 days from today, allowing 5 days time to produce a certified copy of the order to the 45 days, which is inclusive of 5 days time to the petitioners to produce certified copy of the order before the authorities.
Right.
Giving them 45 days clear time to hold such election. Next para, insofar as petitioner numbers 3, 4 and 5 are concerned, namely so and so. The court is inclined to provide that within a extended period of how many days? Notice period is
Notice period 15 days, within 1 month from today, my lord.
within 1 month from today. The said petitioners shall the said petitioner society shall hold
1 month.
their
and 5
AGM.
days. In between time would be taken, my lord. Some
21 days, is it 15 days is time notice,
Yes,
it says. 15 days, you have 15 more days time to hold AGM.
If not held, my
Uh,
lord.
If
some of
not,
the societies, they
okay,
have-
if not already held.
Right.
And the proceedings of the AGM shall be forwarded to the
ARCS,
ARCS.
concerned ARCS.
concerned jurisdictional assistant registrar of cooperative societies for approval.
for approval.
For approval. So with the to the extent is indicative of the representation stands allowed.
Now,
Now in seven, what is the distinguishing fact?
7 is over. I have 9.
No, nine, huh?
Mine, 9.
no, 9, my lord, there is no case. Board is dissolved, new board has come in, earlier board gone. Now new board is, my lord, is constituted and they are running the society. This is infractuous matter, my lord. 9. Lordship may record my submission.
Let there be light.
So, yeah. So far as number 9 is concerned, my lord, our thing was that the board of directors of a particular society failed to convene AGM for the period 2020, 2021 and 21-22.
No, but, Mr. Tagore said that this,
That is submission to recorded, my lord. I do not have instructions on that.
My submission.
By my synopsis to say my case, then his submissions and I have no instructions. That's all.
Board is no longer. Let board.
Only his submissions will be
Elapsed.
recorded on that.
And he has challenged, my lord, the holding of the AGM by the board. He was the secretary. What is was his, my lord, I don't know.
Perfectly.
What-
Exemption was granted for the period Y without granting the exemption for the X. So there was an error in law. We said you have to give exemption first to X period 2020 to 21 and then for Y. They granted only for Y.
Anyway,
And
my
they
lord,
have to
new board
regularize
has
the
come
thing.
now.
I have the
New-
locus.
New board
Certainly.
is running, my lord.
It's a point of law. But now since he has submitted that be made a part of
okay,
record. I
that
have no
first
instructions.
para one will be there same. Huh? Here there is only one society.
One society. Oh, it's a different issue altogether.
No, there is no society, my
Yes,
lord. He is
society.
my lord, in fact, he was the secretary of the board. Yeah. And he has challenged, my lord, that the board should be dissolved. That
Even if
was,
I
my
read the
lord, his
synopsis,
ground.
this is clear.
Now already board,
They-
my lord, has been dissolved, new
Just
board
a
has come.
just a moment.
There are two periods, 2020 to 2021, that's X, and 2021 to 2022, that's Y. Exemption was granted for Y without getting any exemption for X. Therefore, the holding of the AGM was valid there. That was my case.
Mr. Banik and Mr. S.K. Tarudar, that for the case of the petitioner, is that the board of directors of Azad Samavay Samiti had failed to convene annual general meeting for the period 2020-2021 and 2021-2022. First, the board was dissolved by notification dated 27/10/2021. First of however, comma, a notification dated 4/1/2022 was issued by invoking section 130 capital A of the Assam Cooperative Societies Act 2007. By which exemption of the exemption of the provisions of section 39 and 41(2) was granted for the period 21/9/2021, PO2, 21/3/2022, and not beyond. Full stop. Accordingly, comma, the petitioner claims that the new board which has been constituted from Mr. Banik.
No, we say on the strength of that exemption, which was for the period 21-22. Since the 2021 period was not granted exemption, therefore, the granting of the exemption on the basis of which the election notice was issued is bad in law. They should have noticed 1/3/2022 fixing a date for 17th of March 22 for the AGM. This was on the basis of the exemption so granted. I say the exemption is faulty. It gives for the period 21-22 without granting exemption for the earlier 21. So the board cannot hold the AGM. That was our case.
My lord, instead of going into all this, my lord, what I'm submitting,
The earlier
the
year was
challenge which
regular.
was put.
Facts, no, facts I must
lord.
understand.
My lord.
That's why.
A dissolved court was going to hold a meeting. That was our case. Because for the first period, no exemptions was granted.
And not beyond.
All
So
right.
however, comma, as the said exemption was not for a, and not beyond, and moreover, comma, the exemption did not cover the previous period of 2020-21, comma, the
Notice dated 1/3/22 at page 20 was without jurisdiction, as the board still was a dissolved board.
the subsequent notification dated, notice dated 1/3/2022. Where is that?
Page 20.
To hold annual general meeting was bad in law. Which was liable to request.
There was an interim order initially, my lord,
Okay,
16th of March.
it's
which
okay.
says AGM held during the pendency of the writ petition shall be subject to the outcome of the writ petition.
So it is submitted that by interim order passed by this court, comma, the
16th of March.
audited 16/3/2020, it is provided that any annual general meeting held during the pendency of the writ petition shall be subject to outcome of the writ petition. Next, in this context, the learned standing of the Corporation Department has submitted that as per his instructions, comma, the election of the members of the board of directors was already held
My lord, new board has come in.
during the pendency of the writ petition,
Yes, yes.
and the said board also has also been approved by the authorities.
Well.
Post it is also submitted that the constitution of the new board has not been challenged.
Yes, not correct.
By this notice only the board came through. By this 1/3/2022,
No, I understand, but you see, the elections have gone further than to this notice.
Yes.
the entire purport of the interim order was any AGM held, which was so held by 1/3/2020.
No, the things are different, because I'll take care of that, because what has happened is that those people who have been elected, they are no longer parties here. Those have not been amended and brought. So therefore, it would not affect the people who are not parties to that proceeding.
What I've on my lord is that as on 16/3/2022, holding of the AGM was not stalled, but it was permitted with a rider. It will be subject to the outcome of the writ petition, meaning thereby, if this notice is without the protection of law, and the notice goes. And on that understanding of law itself, the notice was allowed to carry out, to be carried out in the election, in the AGM. This was not the case, that whoever would be subsequently brought in as the directors and all, they would have to be arrayed. This was, you go ahead, but the rider is here. And the rider is, if it is found without jurisdiction, it goes. I am praying before your lordship that the board which had issued the notice 1/3/2022 was without jurisdiction. It was a dissolved board because for the earlier period exemption was not granted at that point of time. And ex prospecto or retrospective, something that via media could not work out under the Cooperative Act. This notification was issued 1/3/2022. Only because this notice was issued, only because 4th of January 2022, the exemption was granted. And that exemption itself was 21/9/21 to 21/3/22 and not prior. And both were disqualified because 2021 and 21/22 exams were not held.
My lord will kindly see, my lord, in this case, the challenge was in respect of the earlier board. That board is no more now. A new board has come. This matter has become infructuous.
If he says that after the notice, subject to correction, I'm not. 1/3/2022.
New board has come.
1/3/2022, AGM was held. The body was formed. That body has gone. Another body has come. Then I have to.
Especially because to
Yes,
23 is
election
there,
has held, my lord.
23 is there, that's what he's
Absolutely, my
submitting.
lord. That is what I'm submitting.
Submitting file. So far as the 1/3/2022 notice is concerned,
No, 1/3/2023, 1/3/2022 board.
It is in respect of AGM. Now election.
This
has
is
held.
only election,
Yes.
AGM. This is only an AGM.
AGM.
Here it doesn't say about the elections. That's
No,
why
no,
I'm
that
not
is
able
not
to
about
follow you.
election. No, that is not about election. Election has been held pursuant to honorable court direction in another case. After court's final permission.
This is only AGM.
It is
The election is
infructuous
not
matter,
there.
man. It has become infructuous.
It is something that subsequently subsequently election of the board of directors of the Azad Samavai Samiti Limited has been elected in an election held subsequently.
Well,
And the constitution of the board of directors has been approved by the competent authorities. Now this matter has become infructuous. First one, next, in view of the nature of submissions made by the Learned Standing Council for the Corporation Department, that post 1/3/2022, an election has already been held in respect of the board of directors of the said society. Now this matter stands closed, having been rendered by purpose.
so now, my lord, in respect of other matters, lordship may close it by saying that they have spent their 5 years course. Somebody is, my lord, is running 7 years. Departmental officer will hold the election. They will participate. Disqualification will not apply. Within 45 days.
Time to file affidavit. That is why also, and in the order also, it has been
No,
reflected.
that is okay, but factually, do you dispute that, that fact?
Lordship, yes. New cases are also pending pursuant to lordship in spite of the interim order passed by the honorable court lordship.
No, that is
they have
okay, but
dissolved our body
when,
and a one committee, one man committee has been formed. Lordship may kindly peruse the order dated 9/3/2022 onward. The interim order passed by the honorable court. And following,
no, that's okay, but do you dispute that this, you see, the elections were held when?
in that case, lordship has just now passed order in the first second. Lordship. Similar order was passed in earlier round of litigation. Lordship may kindly see. page
Election held
20
in 2016.
Page 28.
Even 16, my lord.
Lordship,
Yes,
page 28. And the operating person is at page 30. Lordship.
page,
Page 30. That is in the earlier round of litigation. That is WPC 4/5.
no, you see, Mr. Das, when was your last, election held?
Lordship, our last election was held on 27/8/2016.
16, so therefore, you see, your board cannot hold the meeting.
7 years.
This election has to be held by the departmentary.
Yes.
You can only participate, we
No,
can
no, sir.
provide that.
That is why Lordship, that interpretation of section 130A was required. That is why Lordship may kindly peruse the interim order passed by the honorable court. There was a specific order, Lordship.
16-3. 16-3 to 2023 also.
Yes.
That interpretation, if you notice, if I ask you from last and you go extra copy on the interim order pass earlier will continue till the next date of 16. And also in the earlier paragraph, also it is required to be held every year in accordance with section 39 could not be held. It is the contention of the petition that though powers have been exercised under 5138 that could perhaps not be adequate to regularize the agent of the various society. And thereafter also there is another order. On
Mr.
24
Das,
to
that is
24
that is the precise reason we are extending your, we are permitting you to participate in the election. But to say that you will hold the election, that is not permissible.
Now, Lordship, in spite of the interim orders passed by the Honorable Court, they have dissolved our body and a one-man committee has been formed. For that, Lordship, we have filed a contempt petition. In the contempt petition, Lordship, notice has been issued. And we have also filed.
No,
another-
we are not permitting you. You see, you could have held it, but now since the one-man committee has taken over, we will not permit you to hold that election.
That permission was denied by them, Lordship. It was not our fault. Lordship, may kindly pay our writ petition, Lordship.
Yes.
Yes, Lordship, pursuant to the Lordship, first order passed by the Honorable Court, Lordship. Lordship, make page 37. That impugn rejection order. Page 37. Whereas for containment of the COVID-19, the Disaster Management Authority has imposed various restrictions on gathering of people in both urban and rural areas. Also, periods losses. And whereas for the purpose of application may not be deemed to be covered under exemption granted for holding of meeting, gathering at open or closed spaces. In view of the above, application for holding a GM election of the society with not is hereby rejected. In spite of the court order lawsuit, they have rejected. Although we have full preparedness, we have taken resolution. In resolution, we have also annexed in our petition also. At page from page 31 also. So that rejection order lawsuit, we have challenged in the present inspection. And after that lawsuit, the interim order has been passed in the by the Honorable Court. And also making an observation that interpretation of section 138 will be required. And in the second writ petition which we have filed lawsuit, that has been heard by another bench lawsuit. It has been extensively heard, and the matter is almost part heard also. And just lawsuit that amendment also that objection and those were directed to be produced by my learned friend also. Statements and objects. When this section 138 or
138 of?
section 138 was when my learned friend was directed to produce before the statement on objects. When section 130, when the 138 amendment was amended. What was the decision taken there also? Only that part is remaining. And because of the interim order clauses, my second petitions, we have in the contempt case also notice has already been issued by the Honorable Court. Then Lordship, there is one more order on 24 to 2023.
Look, Mr. Das.
Your lordship is referring to the object of the proposed amendment is to bring competitiveness and professionalism amongst corporate. There should be an end of monopoly. Lordship. Exactly, lordship. In our case, lordship, we had our full preparedness.
No, that is okay, but you see that aims and objects are something which is,
That is
it
because-
helps your
because-
argument.
Because in some cases, lordship, the extension is given for 6 months and another 6 months.
No,
So
that is
after
okay.
expiry of the 5 years, come another 1 year.
I understand, but that's why we are extending you, giving you that liberty to, what you call, to participate in the election. But we can't, you see, this power to invoke, can there be a mandamus to the state government to extend it for a period, which is not, this is in a notification? Can that mandamus be issued?
Lordship, here in this case, lordship, there are specific interim orders passed by the honorable court in the instant.
No, that is okay, but
And
you see,
lordship, on the stand of the interim orders, lordship, we have filed another writ petition after the dissolution. After the formation of the one-man committee. Lordship, this matter can also be taken along with that said writ petition.
I am not tagging. You make a prayer for adjournment, that is all. I am not tagging.
In that case, lordship, may kindly fix the matter next week. In the meanwhile, also we will try to that coordinate benches, I think we will be sitting on 15 and we have already given an application for on next Thursday also can. take it.
Not Thursday.
And in the contempt case also, notice has been issued by the honorable court also. In that case, also on 27, also. 27.
I'll fix on a regular, what you call, motion days, not on a hearing day.
26.
On the both sides are duly represented on the prayer made by Mr. S.K. Das, counsel for the petitioner. Matter stands adjourned today. List on. Give it after vacation on a motion day.
Before vacation also on 26.
You see, in one case, if order is passed, every other case, it will same order will follow. You don't have to make a cost list of 100 cases. 21.
In fact,
21/7.
Lordship had passed the order in item 7. Petitioner 1 and 2 stand, my lord, in same footing with them.
It's
Lordship
okay,
has already
Mr.
passed an order.
Same footing, but
Mr. Das,
in our
Mr.
case
Das
also-
wants to do it.
but our
later
body has
on.
been dissolved also.
Yeah,
In this case,
and-
our body has been dissolved. Lordship may kindly extend the interim order clause till the next date of hearing. Lordship may kindly extend the interim order clause.
No, you can't extend that body if it's closed. I'll have to make an observation. The body, the term is already lapsed.
But that is an illegality in spite of the interim order passed by the honorable court also. That is a violation of the honorable.
It's
court
an
order.
operation of law. There can't be an illegality. There can't be what you call estoppel against the law.
Correct. That
If
is
you want,
my
I can make an observation, but that will harm you.
In other cases, Lordship, it has not been dissolved. They are interim orders.
No, but you see, please satisfy me. I'm ready to hear you. You see, can there be an estoppel against law? Can there be can be stay on operation of law? Can I do it? Do I have the power to say that that the rigors of law would be would stand invalid? Can I say that?
No, I'm not saying that. In and in other cases also, Lordship, the 5-year time has not expired.
No, you see,
That
this is one matter which I am hearing. Please complete this matter. Will come to another matter. Now you are saying that operation of the default clause would not apply. My simple question is, can there be an estoppel against law? If in one case the law has not been enforced, can in another case negative equality be brought and then said that the rigors of this 41(6) will not apply?
And we have been given extension only for 6 months. We sought another 6 months period of extension. That has been denied also.
No, that's okay. That's
that
why
is
you
why
see,
what-
that's why we are protecting you by saying that it will not be a bar for you to stand in the elections. But if you need a order of extension of the interim order, then you have to satisfy the court.
Lordship has taken care of their grievance because they cannot have a right to remain in office beyond the term.
No,
They
that's
can have
okay,
a
Mr.
right to
Das may-
participate in the election. Lordship has given them, my lord.
Mr. Das may have some
My
good
lord.
argument to make,
Yes, yes.
but the estoppel against law will be very difficult. Yes, Mr. Das. No, what is your submission?
No, adjourn, Lordship, after vacation. yeah, Lordship.
Because if one case your matter is decided, in other cases, same thing will follow, irrespective of whoever's case is. Mr. Das may get the benefit, Mr. Banik may also get the
But
benefit.
Lordship, there are instances, Lordship, even after expiry of 6 years, Lordship, they have extended. Lordship, I can produce those, and those things have been produced, Lordship, in the other cases. Lordship.
No,
And that has been
Mr.
extensively
Das,
argued, Lordship.
Mr. Das, there are two things. Number one, if you are arguing, you argue.
Lordship,
If you're
we
not
kindly
arguing,
adjourn,
then-
Lordship, already
And
time.
then you will not argue. Because the question is, if you are making a legal submission, then I'll have to tackle it in my order.
Lordship, we kindly simply adjourn the matter. Obliged.
15,
Matter may be completed. Some time is required in this matter. Matter relating to the remove of a secretary of a cooperative society lottery. This is the next.
Oh, acha, this is not a matter of the same, year.
No, 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 this is
Okay,
the
then we'll have to hear it some other day.
some other day.
Next week. So there is a stay.
Huh?
There is a stay, so you can next week.
Okay. Due to positive time matter, what's also the represent, due to positive time, the matter could not be taken up today. List again on. See, and give a date. But the dates are on the, on a, what you call motion day, because all these Tuesdays and
Friday.
Thursdays are all tied up.
Friday.
जीते दिया आपने फ्राइडे बस मंडे जने का दिया
21st,
16. Same due to positive time matter could not be taken up today. List in the next week.
for hearing item number 6.
Yes.
My lord, is against the confiscation of a vehicle. Well, surprisingly, it's a order of a district judge, my lord, London district assistant judge. And petitioners invoke 226. Penal corner.
Zoom it.
Some other day, my lord, it's-
I've gone there. It's just gone. Other matters I will not take up today. Mr. Prakash, you are sitting.
He wants to.
Yes.
My lord, one matter in part 2 list, item number 8 was to be taken today. Can you use that date? Maybe for that, like-
We'll take it up whenever it is next call. I'm not fixing a date.
Alright.
Yes, Mr. Gogoi,
My lord.
after the appellate order is passed in a confiscation proceeding,
Madam.
there is no second appeal. So they
There's
will
no
have to come and writ appeal, writ petition.
Uh,
Or what is the, according to you, what should be the manner of
Probably,
challenge?
Apart from, there's a judicial order under challenge. Certiorari can certiorari will, my question, I am also a bit confused. Because going with the Radheshyam citation, my lord, case of 2015. It says, clearly says, my lord, that civil code orders are not amenable to 226.
No, it's not a civil court who are taking up this matter. Confiscation proceeding is a criminal.
It's a district judge, my lord.
proceeding.
That was, I was confused. I was looking up to the court for
No,
some.
it's a criminal proceeding.
So that's okay.
It-
Then,
it-
then,
it
then that
is-
case, that limb goes. my lord.
This is not a what do you call civil-
Yes,
no,
I was
you
confused.
see-
my lord. I was not.
No,
very
it's
sure.
okay, but even if it is a civil or criminal, if there's no appeal provided, second appeal provided
Yes,
for.
yes, he can be
then it
remedialess. Can be remedialess. I
can't be
was
remedied, means-
under impression, my lord, the afforded application would be more appropriate, my lord.
Huh?
482 application would be more appropriate, my lord. And that apart, my lord.
Yes, you are
Uh,
right. 482, when you say about 482, you appear to be right.
Yes. And because my lord, to invoke 226, certain lordship is very, even we have enlightened from your lordship that either jurisdiction has to be extraneous, my lord, either without authority of law, either some other parameters, 3-4 parameters of randomness and certiorari, my lord. And apart from that, my lord, this order is, if lordship is taking up the matter, then I'll. Otherwise.
Today
some
I may
other
not
date
have
also.
time, if it wasn't late. Yeah, yes, Mr.
Some
Saikia.
other date also.
Insofar as
basically,
insofar as the
challenge is
issue of writ petition is concerned, vis-a-vis 482, what do you have to say?
Well, basically the confiscation proceeding under section 49, that is an administrative action, and the institute provides that
No, it's
against.
not administrative. Is it administrative? Any authority has hold it to be administrative?
No, otherwise, from the language of the statute, my lord. This confiscation only, my lord, for the purpose of, my lord, keeping the, my lord, goods intact, my lord, till the, my lord, any prosecution that is launched.
No, it's a
No, my lord, there's a
confiscation
two parallel
proceeding.
procedure.
This is a confiscation proceeding. It's a full-fledged proceeding under the Forest Act.
And the- my
Because,
submission, my lord,
because you
two
see,
part, my lord.
no, I'll tell you why. That submission Mr. Gogoi did not make. But you see, the problem is that if it's an order of the court, under
Because the
two,
statute provides that the appeal would lie to the, my lord, to the district or session judge.
49C.
Lordship,
Correct.
had there been a provision, my lord, it
No,
would
no,
lie
no.
to the, my
No,
lord,
no,
Assam
no.
Board of Revenue or
No,
any
no,
other,
no.
my lord, higher
I'll
authority.
I'll tell you why.
My lord,
You see-
confiscation under two sections, one is 49, my lord, and other is 51. So far as 51 is concerned, that is a criminal process. Because it is after the conviction.
This is.
No, these are two separate proceedings. Criminal proceeding vis-a-vis,
Mr. Seki, I'll tell you why. You see, in a writ proceeding, when let us say any order of any tribunal or anything is challenged, there is a requirement of making that tribunal a party. Say Assam Board of Revenue. A writ petition is filed. We are required to impede Assam Board of Revenue as a party. Yeah, order of CAT is challenged under 226. CAT is made a party. The exemption is for is under two acts. Number one, Judicial Officers Protection Act 1860. That gives exemption to the what you call courts to be prosecuted. Second is Judges Protection Act 1980. That exempts judges. Judges means magistrates also. So they are exempted from the prosecuted. Thirdly, there is a constitution by judgment which says that judicial officers cannot be made parties and prosecuted because it says writ does not lie against the court. So these are two principles vis-a-vis one judgment of the what you call Constitution bench, another judgment L. Chandra Kumar, which says that writ petitions against the order of a CAT can be challenged. So therefore, in CAT and other things, there the procedure is that they are made parties. Number one, but in 482, you are not required to make the court a party. Therefore, you can proceed. So you see, if you proceed under 226, then the jurisdictional court having not made a party will make your writ petition not sustainable because of the fact that this is not a tribunal within the meaning of
It's also not a tribunal, my lord, because the authority has been prescribed where the appeal lies. So far as the Assam Board of Revenue and the CAT, they are made party only to call for the records. But they are not issued any so-called notice to them to submit a reply or something like that.
no, it's a
Only
notice,
for calling
same
for the
notice
records.
goes to all.
Because official of the registry have to call for the records. So that is the reason why these are made party. Now here, in this particular case, you will find there are two kinds of confiscation. One is under section 49(4), that is by the authority themselves. And the another is 51.
No, 51 is different. 51s are tools.
Yes, well, here also it's etc. Tools etc. Otherwise, details are given with tools, boats, carts, and cattle used in commission of such offences. Heading is on tools and etc. This is after the conviction by the court, because conviction can be done only by the court, not by the authority. And even after section 49(4), there is another section 49(a), which gives them the power to release the goods to the payable. They cannot go for disposal after this confiscation. But so far as court is concerned, my lord, that is a offense report is submitted to the court. Then the CRPC follows. That conviction is done. And thereafter, this disposal of the confiscated goods are also been done. Now here the power exercised by the authority is under section 49. And against that, since 49C provides that any person aggrieved by any order under section 49B or 49(4) or section 49B may within 30 days from the date of communication to him of such order prefer an appeal to the district judge having jurisdiction to so and so. So the district judge has been mentioned. And now your lordship will kindly find it is not a district session judge. Perhaps let me we have something to type in.
As regards that,
Appeal is
No. It'll be difficult to accept your argument. You see, for a simple reason, please come to pay section 49.
Okay.
Correct. Under 49, there's a that a foreign officer has been committed, then it may be seized
yes.
and liable for confiscation. Correct.
Yes.
Now you come to 49C. 49 says any person aggrieved with the order under 49(4)
Yes.
can file an appeal. So therefore,
It's confiscation.
but under 51, the order is not passed under 49(4).
No.
So therefore, appeal under 49C is not envisaged for offense for confiscation under 51.
But that's what I said. There's two proceeding, two confiscation proceeding. One is by the authority, other is by the court. When the person is sent up for trial or prosecution, offense report is submitted before the court. The prosecution is initiated, and thereafter the CRPC provisions follows. The conviction is being made, and thereafter section 51 comes into play. That is one part. So far as this is concerned, the moment it is seized, it has to be placed before the authorized officer. And if it is not, the goods cannot be produced before the authorized officer. In that case, a report may be submitted. On the basis of that 49, this 4 comes, he may go for the confiscation proceeding. He cannot go for disposal of after this confiscation. He cannot have the power. The authority doesn't have the power to convict a person. The authority doesn't have the power to disposal of the property as has been done after the confiscation by the court. So what therefore I submitted this perhaps is an administrative action, and will find even in the 49C, it is mentioned district judge, the order has been passed by the session judge, and the appeal is registered as a miscellaneous appeal. It is neither a criminal appeal nor as a civil appeal, it is a miscellaneous appeal. Whether this confiscation proceeding was as per the provision 49 or not, only to scrutinize that part. And in fact, several cases of this code, of course, the maintainability, I did not go through that, but from this, what I feel. Petitions, large numbers of writ petitions have been filed and few of them I have. These are all writ petitions, these are.
Let that part. But what has happened now here? Again, I'll come to 49C, madam. It mentions about a district judge. Here I hold the judgment of this honorable court where it says, though my lord, in Assam, both the same person, but they hold a different jurisdiction. And since statute says the manner in the act has been done in that manner, no other manner, my lord. That my lord Nazir, some citation was there. So my lord, it has been referred back again to the district judge to try afresh.
So, well, his submission is that order passed by the session judge is nullity. What I
Since the
could
statute says, madam,
Because
that
this
manner in a
49
manner
says
which
the
is
district
done,
judge,
has to be done in that manner, my lord.
and the order has been passed by a session judge, so it is a nullity, my lord, according to his submission.
That is one facet, madam. Para 4, 5 and 6. ইয়াতে আছে কিতাপখনতে আছে মোক আমাৰ নাম কিতাপখনতে আছে
We send it back. Here the court directed that it was lack of jurisdiction. Accordingly, writ petition is allowed and impugned order is set aside. The respondent, if she so desires, may file appeal before the competent authority, that is the district judge Sonitpur. Now, this 49C, you give a copy to Mr. Saikia.
Yes, I'm giving. And this has been recently followed also, my lord, in few cases, just handing around. Similar matters, ma'am. Orders has to be made by the district judge, but it has come from the session judge.
We go through it, we'll take it up on Friday.
Well,
That was registered as criminal appeal, my lord.
The
And
same
that-
thing, jurisdiction is sessions.
Here under 227 had been filed. But you will find the revision has been filed by the petition under article 227. of
By the
Constitution.
DFO filed it under 227.
Challenging the order dated 23/7 passed by the. London
So therefore,
Session
the
Judge
session judge would not have jurisdiction.
in criminal appeal number so and so, whereby the order of confiscation of track being under so and so.
So if this is the law laid down, you have to permit you to file an appeal under 49C before the district judge.
yes, my lord, it's Nazir Ahmed, my lord. Well settled principle, my lord. If a statute provides for the thing to be done in a particular manner, then it has to be done in that manner, in no other manner. Since it says district judge, well, it has going to be to district judge.
Sign, of course, and I'll go through and conduct a submission on this.
Friday,
Right.
both sides are,
Whole thing. is
both
that-
sides are represented due to positive time matter could not be taken up today. Next, however,
Let's get one more thing. before-
Mr. D. Gogoi Leonard, standing counsel for the Forest Department, has referred to the judgment of judgment passed by this court in Divisional Forest Officer come authorized officer versus Maya MAYA DOLO comma within bracket 2005 bracket close 1 GLR 133 and submits that although district judge and session judge are normally one person, But in this case, the order passed by session judge was held to have lacked jurisdictional authority. And it was directed that the matter be that a fresh appeal be filed before the district judge. Full stop. A copy of the said order has been provided to the to Mr. P.J. Sekar and senior counsel for the petitioner. Due to positive time, matter could not be taken up today, list on Friday.
Always, madam.
My lord, it's a legal issue, my lord, it is better to decide, but what is happened here, my lord? Subsequently, the offense report was submitted before the court. Offense was registered, but that has been ignored by the state government because of the circular, my lord, of so, my lord, as on today, there is no, my lord, proceeding. And this confiscation can be done only while
No,
the
that
proceeding is
I
on.
can differentiate, madam. Is up to parallel processing serving different purposes. This I can showcase. madam. I can demonstrate.
The interim order passed again. I can do it.
The order passed yes, times extended to the next day of the state.
And it will be listed on the stay or on column, my lord.